Morning, Council. You can have a seat just for a moment, Mr. McAdam. We're dealing here this morning, of course, with the reference concerning the constitutional validity of the Greenhouse Gas Pollution Act. For the benefit of my colleagues on the bench, I'm just going to proceed with a little bit of a roll call in the traditional way. For the Attorney General of Saskatchewan, we have Mr. McAdam and Mr. Jacobson. The Attorney General of Canada, we have Ms. Tellez Langdon, Ms. Sittler, and Mr. Matthews. For Mr. Goodrich. Okay, thank you very much. For the Attorney General of Ontario, Mr. Hunter, Mr. Ryan, and Mr. Lipton. For the Attorney General of New Brunswick, Mr. Gould. The Saskatchewan Power and Sask Energy, Mr. Thera and Mr. Affleck. Canadian Taxpayers Federation, Mr. Hallsor and Mr. Shalashniy. Agricultural Producers Association of Saskatchewan, Mr. Grubb and Mr. Awan. International Emissions Trading Association, Mr. DeMarco, Ms. DeMarco, and Mr. McGillivray. The Attorney General for British Columbia, Mr. Morley. Canadian Public Health Association, Ms. King and Mr. Finlay. Athabasca Chipewyan First Nation, Mr. Awan and Mr. Halsey. Is it Halsey or Huls?
He's in the overflow.
Okay. The Canadian Environmental Law Association and Environmental Defence Canada, Inc., Ms. Wilson and Ms. McClenahan in the other room. Assembly of First Nations, Mr. Wutke, Mr. Carter. David Suzuki Foundation, Mr. Ginsberg and Ms. Gallant. Ecofiscal Commission of Canada, Mr. Elgie and Ms. Chalifur. Intergenerational Climate Coalition, Mr. Hume. Climate Justice et al., Mr. Kowalchuk. And Ms. Yee. Thank you very much. Well, Council, the Court is obviously very much looking forward to having the benefit of your submissions, and we'll proceed with all of that in due course. We have, of course, 2 very full days ahead of us. Everyone has been advised of the order of presentation that we'll be following over the course of the next 2 days and of the time allocations that have been made for submissions. I know that everyone will respect those time allocations, and to assist you in this regard, you'll be able to consult the countdown clock that is running on the screen to your right. Things in the courtroom are obviously a little bit tight, and we hope that especially counsel in the back bench aren't too uncomfortable. I can tell you that we plan to take a morning break at about 11 o'clock, break for lunch about 12:30 to 1:30, and we'll have an afternoon break as well. So with that, Mr. McAdam, I would ask you to begin your submissions. I understand you've asked to reserve half an hour for reply out of the 3-hour allocation that you have. That's not a problem so long as the half hour is a true reply and not a splitting of your case, as you will obviously understand.
Thank you, my Lord. I'd like to begin this morning by providing a brief overview of our argument. Mr. Jacobson and I will be splitting our time this morning. I will start off with some introductory comments. They'll be fairly detailed, but will set the stage for what's to follow. Next, I will turn to the argument set out in our initial factum, that the Act, by virtue of its selective application in some provinces but not others, violates principles of the Constitution, and in particular the principle of federalism. Then I will deal briefly with the constitutionality of Part 2 of the Act, which provides emission limits for heavy emitters. Finally, I will deal with the issue concerning whether the Act imposes taxes or regulatory charges. And I want to be clear, our argument doesn't hinge on whether the Act is taxation or regulatory. We say it's unconstitutional in either event, but it is an important issue, particularly to Sask Power, and therefore I'll spend some time on it. I anticipate being an hour and 15 minutes to an hour and a half. I'll then turn it over to Mr. Jacobson, who will be about an hour. We've tried to coordinate our arguments so that there isn't overlap. Mr. Jacobson will be dealing with the argument concerning the federal government's peace order and good government power. I want to start off by talking a little bit about what this case is about and what it isn't about. First and foremost, from our perspective, this is a case about constitutional law and constitutional principles. It's about the division of powers in the Constitution Act 1867. It's about jurisdiction. It's about what powers the federal government has and what powers it doesn't have. We said at the very beginning of the factum that we filed last July that this is not a case about whether climate change is real or not. The government of Saskatchewan is not made up of a bunch of climate change deniers. The government recognizes that climate change is a serious issue that has to be addressed and that effective measures are required to deal with greenhouse gas emissions. None of that is in dispute. This is not a case about science. This is also not a case about what are the best approaches to tackling climate change. It's not about whether a carbon tax is the most effective way to deal with greenhouse gas emissions. It's not about whether a carbon tax is an indispensable part of any credible plan to deal with emissions. It's not about whose policy is better or will be more effective. And of course, as you know, the wisdom or efficiency of a law is not a matter that needs to be of concern to the court. That's a matter for the legislatures and for Parliament. This court should focus only on the issue of jurisdiction, and in our submission must approach that issue dispassionately. I do, however, need to say a few things at the outset about the government of Saskatchewan's position with respect to the universal tax on carbon that's set out in Part 1 of the Act. It's the government's position that this tax is unfair to Saskatchewan residents and businesses for a number of reasons. First, because we're a rural province. People living on farms can't just hop on the bus to go to town to get groceries. They have to drive their cars and trucks. Second, it's a cold climate. We all have to heat our houses during the winter. Third, our economy is resource-based and export dependent. When it comes to industry in Saskatchewan, whether we're talking about agriculture, potash, or oil and gas, our products are sold in international markets, and the prices of those products are set in those markets. There is very little to no ability for producers to pass on their costs of production to their customers. And we are competing for business with other jurisdictions like North Dakota that doesn't have a carbon tax. So there is a real risk of leakage. Investment dollars will simply flow out of Saskatchewan to these other jurisdictions because companies can operate there less expensively. Some of the interveners have suggested that Saskatchewan is not doing its part when it comes to climate change, that we're looking for a free ride. Saskatchewan strongly disagrees with those sentiments. If you understand Saskatchewan's demographics and our economy, a universal tax on carbon results in Saskatchewan people and businesses bearing more than their fair share of the pain for little in terms of real results, emission reductions. My lords, my ladies, I also feel I should mention briefly what steps Saskatchewan is actually taking to address climate change. We are not doing nothing. Saskatchewan's approach is set out in the document Prairie Resilience that we've included in the record. I'm not going to discuss the details of that document. I just want to highlight a couple of things. First, Saskatchewan has implemented an output-based pricing system for emissions that apply to heavy emitters under the Management and Control of Greenhouse Gases Act. So we have carbon pricing in Saskatchewan. We are not opposed to carbon pricing. The federal government has even determined that Saskatchewan's output-based pricing system meets the benchmark that is the foundation of the Greenhouse Gas Pollution Pricing Act. So Part 2 of the Act doesn't apply to the private sector in Saskatchewan. Part 2 only applies to Crown corporations, Sask Power, Sask Energy, and Transgas. Second, Saskatchewan has recently entered into an agreement with the federal government on standards for the operation of its coal-fired power plants. That's included in the Supplementary Book of Authorities. Saskatchewan has recently introduced regulations to limit methane emissions in the oil and gas industry. That's also included in the Supplementary Book of Authorities. So you cannot say we are doing nothing. My lords, my ladies, the issue in this case in our submission is simply, does the federal government have the jurisdiction to enact the Greenhouse Gas Pollution Pricing Act? Is it legislation that falls under Section 91 of the Constitution Act 1867? And in particular, does it fall under the federal government's power over the peace, order, and good government? But I'm going to suggest that this case is really about something even more fundamental than that. It's a case about the nature of our federation. It's a case about the kind of country we live in. The issue at the heart of this case is whether the division of powers really means anything. Are provinces sovereign and autonomous within the areas of their jurisdiction set out under Section 92 of the Constitution Act 1867? Or under our Constitution, can the federal government step in whenever it thinks provinces aren't exercising their jurisdiction appropriately and act for them? Because that's really what this case is about. The federal government thinks it's a good idea to have a uniform price on carbon that applies all across the country and that applies to all sectors of the economy. Several provinces like British Columbia and Alberta have put prices on carbon in the exercise of their jurisdiction under Section 92 of the Constitution Act 1867. And no one has ever questioned that they have jurisdiction to do this. Clearly they do. And the federal government could impose a national carbon tax. All they would have to do is increase the amount of the GST on fuel. We don't deny them that jurisdiction. But Saskatchewan has not put a price on carbon for consumers in Saskatchewan who are purchasing gasoline or diesel fuel for their vehicles or natural gas to heat their homes. Saskatchewan has steadfastly refused to do so. So what does the Greenhouse Gas Pollution Pricing Act do? It provides that the federal government is going to step in and impose a carbon tax on consumers in Saskatchewan and on any other provinces that haven't imposed a carbon tax in a way that the governor and council, being the federal cabinet, thinks is appropriate. When we prepared our initial factum last July,
McAdam, when you're making those comments, you're referring to Part 1 of the Act or Part 2 of the Act or the Act as a whole?
the Act as a whole. Later in my submissions, I'm going to deal specifically with Part 1 and Part 2. My introductory comments apply across the board to the entire Act. When we prepared our factum last July, we thought the carbon tax might only apply in Saskatchewan. It turns out we have some company. It also doesn't apply in New Brunswick, Ontario, and Manitoba. So the tax applies in 4 provinces. It doesn't apply in the other 6 provinces. So one of the things I'm going to say at the outset, my lords, my ladies, is to think about the type of precedent that that sets. We have federal legislation that applies in some provinces, but not others. Federal taxing legislation that applies in some provinces, but not others. As we stated in our factum, that's unprecedented in Canadian history. we have a situation where the federal government has said that certain provinces aren't doing enough to combat climate change with respect to matters within their jurisdiction. And so they've said, we'll step in and do it for you. That's explicitly what the backstop provides. In our factum, we describe this as a big brother approach to federalism, or an Ottawa knows best view of federalism. In our approach, it's not federalism at all. Before I get into the details of my legal arguments, I also think it's important to talk a little bit about the Greenhouse Gas Pollution Pricing Act itself. It's a long, complex piece of legislation, and I certainly don't purport to understand all of its ins and outs. It reads way too much like the Income Tax Act for my liking. But I do understand the essential features of the Act, and I think it's important to keep in mind that there are two separate parts to the Act. First is Part 1. And in our factum back in July, we described that as essentially providing for a tax on consumers of fuel. Gasoline, diesel fuel, natural gas, those sorts of things. So consumers will see this tax when they pull up to the pumps to fill their vehicles, when they pay their monthly utility bills. But we weren't quite right to describe it as a tax on consumers. It's actually a tax that's applied to distributors. They're the ones who are taxed, and then it's expected that they will pass the tax along to their customers. So it operates very much like a classic indirect tax. Next, there's Part 2 of the Act, and it's quite different. In a nutshell, it imposes emission limits on certain companies, heavy emitters of greenhouse gases, those companies that emit more than 50 megatons per year. So in Saskatchewan, that's going to be companies like steel manufacturers, fertilizer manufacturers, heavy oil upgraders, potash mines, pulp mills, coal-fired power plants. And what happens under Part 2 is the Department of Environment sets an emission limit for each of those companies. And if they exceed their limit, they have to pay a charge. But there are other options. If the company has been under their emission limits in earlier years, they will have earned credits that they can apply to offset the charges, or they can go out and buy credits from somebody else. It's called an output-based pricing system. So how does Part 2 work? What do these emission limits really mean? Well, I think it's fairly simple. If you have a company that manufactures widgets, or maybe steel pipes, or maybe that makes gasoline from heavy oil, if last year they produced 100,000 widgets operating at full capacity, but this year they're going to hit their emission limit when they get to 80,000 widgets, they're going to be faced with two choices. Either we shut down after making 80,000 widgets, or we pay the charge and try to pass it along to our customers. That's the stark reality of Part 2 of the Act. Now, I know my friends are going to disagree at that suggestion. They're going to say, no, 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 there's a third option. All you have to do is find a way to make 100,000 widgets with the same emissions that you used last year for 80,000 widgets. And they're right, that's an option. But it's not going to be easy, and it's going to take time. So in the short term, you're going to have a very real impact on either production levels or prices. That's essentially how the Act works. And the other thing that has to be kept in mind about the Act, about both Part 1 and Part 2, is it doesn't apply uniformly across the country. It applies only in those provinces where the federal cabinet, not Parliament, and I think that's really significant, and I'll get back to that later, has determined that the province's efforts at fighting climate change aren't satisfactory. The Act provides that the Governor and Council determines which provinces Part 1 and Part 2 apply in, and in making that determination, the Governor and Council is directed to look at the stringency of provincial pricing mechanisms for greenhouse gas emissions. And my lords, my ladies, that's just a euphemism for saying, does the province have a carbon tax, and does it meet the benchmark or the backstop? So we end up with the regulations having these two lists, one for Part 1 and one for Part 2. I like to call them the naughty lists, and unfortunately we're on the naughty list. That's how the backstop is implemented. So my lords, my ladies, if you asked me to describe in one word what is Saskatchewan's opposition to the Act, I would say it's the backstop. That's the basis for our constitutional challenge. Before I go any further, my lords, my ladies, I would also like to say a few words about the evidence that has been adduced in this case. As I'm sure is...
Can I just interrupt?
Yeah.
You say the backstop is the problem regardless of whether the act is characterized as a tax or as an exercise of a few sort of good government power?
Yes, my lord. It's our position that the Act as a whole violates the principle of federalism that's the bedrock of our Constitution, and that applies across the board to Part 1 and Part 2. And that applies whether the Act is seen as taxation, whether it's seen as regulation, whether it's seen as something that falls under POG. In our view, the principle of federalism is an overarching principle that applies to all of the heads of power. And I'll get into that in a bit more detail in a few moments. I did want to talk a little bit about the evidence before I get into the legal arguments. Saskatchewan sees this case as about constitutional law and constitutional principles. Therefore, the record that we filed is quite sparse. The essential background documents that show what led up to the enactment of the Greenhouse Gas Pollution Pricing Act, and not much more. Canada has supplemented the record with some affidavits that talk about the perils of climate change and the efficiency of carbon pricing. And then a number of the intervenors have piled on with their own affidavits outlining the impact of climate change on their clients, what they think the best policies are to combat climate change, and criticizing Saskatchewan or Saskatchewans, what they say are our lack of efforts to deal with climate change. It's Saskatchewan's position that most, if not all, of this evidence is irrelevant and doesn't need to be taken into account. The fact that climate change is a serious issue does not override the Constitution. It doesn't override the Constitution any more than the Great Economic Depression of the 1930s overrode the Constitution. The Great Depression didn't mean that the Bennett government's New Deal legislation was constitutional. All of that legislation to implement unemployment insurance and orderly marketing was all struck down by the Supreme Court and the Privy Council. And we think there are analogies to what's happening here. And also, I don't want to be overly critical of my friends, but I think at least some of the intervenors, and perhaps even my friends from the Attorney General of Canada to a certain extent, take the position that the issues in this case are just so darn important, so vital, that the federal government has to have jurisdiction. They can't be left to the provinces. The provinces can't be trusted to deal with something this important. And our position is that simply the wrong approach to constitutional interpretation. The importance of the matter doesn't determine who has jurisdiction. Jurisdiction is determined by the terms of our Constitution, its history, the principles that underlie it, and the cases that have interpreted it. My lords, my ladies, one of the other things that I wanted to do is set out briefly for the court Saskatchewan's overall theory of the division of powers and the interplay between federal and provincial jurisdiction. I think that will be helpful in understanding the detailed submissions that are to follow, and I think it'll also put this case in a bit of broader context. And I want to refer to a couple of other cases that Saskatchewan has been involved in and is involved in. First, we're involved in a reference case in British Columbia dealing with the Trans Mountain Pipeline. And we're supporting the position of the federal government in that case that the pipeline is an interprovincial work and undertaking, and that provincial laws that interfere with the operation of that pipeline do not constitutionally apply. We were also recently involved in the reference case concerning the federal government's pan-Canadian securities legislation, and we supported the constitutionality of that legislation because it was based on cooperative efforts between the federal government and some of the provinces. Not all of the provinces signed on to that legislation, but we agreed that that was constitutional. So, my lords, my ladies, Saskatchewan cannot be characterized as some rogue province that simply goes out and fights federal jurisdiction at every turn. We pick our fights based on our principles, not simply self-interest. And I would sum up Saskatchewan's theory of the division of powers as follows. The powers set out in Section 91 and 92 of the Constitution Act are essentially exclusive powers. There are only a few truly concurrent powers under our Constitution. The power over the export of natural resources in Section 94A, sub 2, the power over old age pensions in Section 94A, agriculture and immigration under Section 95. This doesn't mean that we're saying there can't be overlap, or that we're rejecting the double aspect rule, or that laws of one level of government can't have incidental or ancillary effects on matters within the jurisdiction of other levels of government. But it does mean that for most matters, they will fall either within federal jurisdiction or provincial jurisdiction, not both. And that a vigorous application of the pith and substance doctrine will reveal which government has jurisdiction. And we would caution against the trend of recent years, and it's a trend that I think some of the intervenors are urging upon this court, to see almost everything as having a double aspect or being the subject of concurrent federal and provincial jurisdiction. And we caution against that view for three reasons. First, it doesn't reflect the words of the Constitution, which talk about exclusive powers. Second, it doesn't reflect the intention of the Fathers of Confederation. It was not the wishes of Sir John A. Macdonald for a legislative union that prevailed during the constitutional debates. It was the wishes of people like George Brown from Upper Canada, Sir George Etienne Cartier from Lower Canada, and the Maritime delegates for a new country that had a strong central government, but strong provincial governments as well. That was the Confederation bargain, and it's summed up in the phrase diversity and unity, not one or the other. And our third concern is that this view of everything being concurrent or subject to double aspect will ultimately have a centralizing tendency, because if everything is concurrent, the federal government can pass laws, and those laws will prevail under the doctrine of federal paramountcy. So ultimately, in our view, the Federation over time will wither and cease to exist. And I think that this is a perfect case for how these principles have been overlooked. When this reference case was launched, we didn't even know the constitutional authority that the federal government was relying upon. The Minister of Environment had been quoted as saying the government was relying on its power over pollution and the environment. Well, anybody that's picked up Hogg's textbook on Canadian constitutional law knows the federal government doesn't have jurisdiction over the environment or pollution. They aren't matters that are assigned to either level of government under the Constitution, and they aren't concurrent powers either. The Supreme Court has confirmed this a number of times. The Old Man River case is one example. Rather, both the federal and provincial governments have jurisdiction to deal with the environment and pollution as aspects of the jurisdiction that they already have. In each case, there has to be a constitutional hook to hang your hat on, one of the specific powers in Section 91 or 92. Neither government has an all-encompassing jurisdiction to deal with pollution or the environment. It's a divided jurisdiction. The Constitution mandates it to be a divided jurisdiction. I also want to talk briefly about pith and substance analysis. And I'll do so from a fairly theoretical perspective, and I'll leave it to Mr. Jacobson to discuss the particulars of the pith and substance of the Greenhouse Gas Pollution Pricing Act. In the initial factum that we filed, we suggested that it wasn't necessary for the court to do the traditional pith and substance analysis because, in our view, the legislation is unconstitutional on a more fundamental basis because it offends the principles of federalism. And that remains our position. I would point you to the Supreme Court's recent decision in the Pan-Canadian Securities reference from last November as an example of where the Supreme Court took a similar approach. In that case, one of the challenges was that the legislation was inconsistent with the principle of parliamentary sovereignty. And the Supreme Court dealt with that issue as a threshold issue before turning to a pith and substance analysis. And that's exactly what we're suggesting should be done in this case. But I also want to make it clear that we're not afraid of the traditional pith and substance analysis. And we all know that pith and substance is the exercise we go through to determine if the matter of legislation, will determine what the matter of the legislation is so that we can slot it into the appropriate head of power under Section 91 or 92. And in doing so, we look at the legislation's purpose and we look at its effects. I have a couple of things to say about that. First, the whole point of doing the pith and substance analysis is to determine which head of power the legislation falls under. But in this case, the federal government is saying it doesn't fall under any of the heads of power. They're asking this court to create a new head of power called greenhouse gas emissions. And my submission is that that should always be a last resort. The goal should be to slot the matter into one of the existing powers if that is at all possible. And I think that we can do that in this case. It's just unfortunate for my friends, those aren't all federal powers. And my lords, I'm going to make a couple of references to Justice Betts' decision in the anti-inflation reference case. And we see many, many parallels between this case and the anti-inflation reference. Justice Betts wrote the judgment that was supported by the majority of that court with respect to the general concern branch of the POG power. Justice Betts was also recognized as a constitutional scholar on that court, and I think his comments about pith and substance are particularly relevant to this case. And he started off by saying, well, we shouldn't be inventing new names for old things as part of the pith and substance analysis. You can't just group a bunch of things together and call it a new subject matter for legislation. And he specifically said that things like the environment and pollution can't be seen as distinct constitutional matters. They're just a bunch of matters that are already covered by the division of powers. And he adds a very important caution. He says if we accept this kind of approach, it'll ultimately lead to the end of the Federation, because anything and everything could eventually be brought under the POG power. And I'll give one specific example from his judgment. At page 452, he talks about what if the federal government enacted a taxing law to fight inflation? He said the pith and substance of that law would still be taxation. That's the matter of the law. It's not an inflation law, it's a tax law. And that's exactly the proposition that we're making in this case. The other thing that I would say is that in this case, the Attorney General of Canada is attempting to do exactly what was done in the anti-inflation reference, but from the opposite direction. Instead of compiling a bunch of things into a broad category, she's suggesting that we can chop things up into little bits, and then we can call each little bit a new matter for the Constitution. So the federal government isn't claiming jurisdiction over all kinds of pollution. They're only claiming jurisdiction over 7 specific greenhouse gases. But in my submission, that simply allows the federal government to do indirectly what they can't do directly. They can't take over jurisdiction over pollution by one big step. they're proposing to take over jurisdiction by 100 little steps. Either way, we say it's constitutionally impermissible, and it's exactly what Justice Betts warned against 40 years ago.
Isn't the Crown-Zellerbach decision an example of the Supreme Court carving out a bit of pollution and finding that it had a sufficient unity and identity and so forth to make it a freestanding head of federal power?
The Crown-Zellerbach case is a case where the federal government recognized jurisdiction over marine pollution under the POG power, and Mr. Jacobson will be addressing that in his comments. We think the Crown-Zellerbach case is distinguishable. We think that the analogy between Crown-Zellerbach and this case, there's a clear distinction in Crown-Zellerbach between pollution in saltwater and pollution in freshwater. Again, something my colleague from the Attorney General of New Brunswick is going to address. We think the analogy between this case and Crown-Zellerbach would be if the legislation considered in Crown-Zellerbach had provided for the federal government to regulate emissions in freshwater lakes and rivers hundreds of miles from the sea. So Mr. Jacobson will explain the grounds for distinguishing that case further on. But it's the example, and I think we would say the anti-inflation reference case and Crown-Zellerbach are the two main cases to consider in this reference. The other point that I wanted to make with respect to pith and substance is you have to take into account both purpose and effects. And with the greatest of respect, I think some of my friends have just focused on purpose. The purpose of the act is to save the planet, to meet the Paris Agreement commitments, to reduce greenhouse gases. But they overlook the effects. They overlook the legal and practical effects. And I've referred to those before. What are those effects? Consumers are going to pay more when they purchase gas. Businesses are going to be told, either shut down how you operate or charge more for your product. Those are the practical effects. You can't ignore the effects, and in fact, I would go a step farther, and here I would refer to another passage from Justice Betts' decision in the anti-inflation reference. He said at page 452, in order to characterize an enactment, one must look at its operation, at its effects, at the scale of its effects, rather than at its ultimate purpose, where the purpose is practically all-embracing. And he said that in connection with the federal government's wage and price control legislation in the 1970s. As indicated, we see many, many parallels between this act and the wage and price legislation that was considered in that case. They're both all-embracing. They're both all-encompassing. So what I would say is that based on those comments from Justice Betts, effects are more important than purpose. Purpose can't override effects. You can't ignore the effects. My lords, next I would like to turn to the argument set out in the factum that we filed last July, based on the principles of federalism. At the outset, I would say two things. First, Saskatchewan believes that the act is contrary to the principles of federalism that are the bedrock of our Constitution, and that this is an independent and standalone reason for holding the act to be unconstitutional. But second, we also say that considerations of federalism are front and center in any argument concerning the national concern branch of POG. The court must look at the implications for federalism in considering the federal government's argument that it has jurisdiction to enact this legislation under the POG power. So there's necessarily going to be a bit of overlap between what I have to say about federalism and what Mr. Jacobson will be saying later this morning. I'll leave it to him to talk about the impact that this legislation has on provincial jurisdiction and what the effect is on provincial powers. I'll confine my comments to the backstop nature of the legislation, to the fact that the act applies in some provinces but not others. I don't think I need to say much about federalism. Canada's a federal state. We have a federal government in Ottawa with certain powers, and we have provincial governments with certain powers. Federalism has been recognized by the Supreme Court in the Quebec secession reference as one of the fundamental underlying principles behind our Constitution. The Privy Council and the Supreme Court have dealt with the principles of federalism many, many times over the years. And I say there are two key principles that have emerged from those cases. First, the provinces are not subordinate to the federal government in any way. Second, the provinces are sovereign and autonomous when it comes to their spheres of authority under Section 92 of the Constitution Act 1867. So our question in this case is whether those principles really mean something. It's our view that they provide an enforceable legal standard against which the Act can be measured. And it's our submission that the Act is offside of those principles, and therefore it's ultra vires. And my lords, my ladies, I don't think I'm suggesting anything extraordinary or unprecedented here. The courts have relied on the principles of the Constitution, written and unwritten, as an interpretive tool with respect to the heads of powers many times. That's nothing new. And what we're asking the court to do is use those principles as an interpretive tool. We're not asking the court to dispense with or override the written terms of the Constitution. Not at all. And in this regard, I would point you to a number of things. First, there's an article written by former Chief Justice McLaughlin of the Supreme Court, which appeared in the New Zealand Journal of Public and International Law in 2006. It's referred to in the factum filed by the Intergenerational Climate Coalition. And she discusses the legitimacy of the courts relying on these types of fundamental principles. And she makes it very clear that in appropriate cases, courts can and must rely on these sorts of principles to strike down legislation.
But is your position isn't that this concept of federalism that you're advancing is an interpretive tool. You're suggesting that it's a principle that trumps what would otherwise be validly enacted federal legislation.
It's a tool that the court can rely on to interpret the federal government's powers under Section 91 of the Constitution Act 1867, and we say that when you apply that tool to the legislation and you look at its uneven application across the country, and in particular the reasons for its uneven application across the country, because of the federal government's disagreement with a policy choice made by the province of Saskatchewan with respect to matters within its jurisdiction, that principle leads to a conclusion that this is not within federal jurisdiction. So whether that's an interpretive tool or an independent basis to trump the legislation, I think the result at the end of the day is the same either way.
But you have to help me understand what it is. What's your position? Is it an interpretive tool, or is it a principle that trumps what would otherwise be constitutionally valid?
I think those are two different ways of saying the same thing. I think an interpretive tool can lead you to saying this piece of legislation is inconsistent with the Constitution, that it trumps. We're not saying it trumps the written words of the Constitution. We're saying that you need to use it to interpret the Constitution and interpret the various heads of power in the Constitution, and that can and should lead you to the conclusion that this legislation is ultra vires or is unconstitutional. And Chief Justice Richards, the example that I would give is the provincial court judge's case from 1997. And in that case, and in particular at paragraph 95, the judges said that you can look at the preamble to the Constitution Act 1867 and these unwritten principles, and they are the means by which the underlying logic of the Act can be given the force of law. My lords, I would also refer to other cases. I've included an excerpt from the Manitoba Métis Federation case in our supplemental book of authorities, and there's a case where the court relied on an unwritten principle of the honor of the Crown to hold that Manitoba's limitation statutes did not apply to a claim based on the Manitoba Act 1867, or the Manitoba Act 1870, pardon me. I'd also refer you to the case from 2015 between Quebec and the federal government about the dismantling of the gun registry. 4 of the judges in that case, including the current Chief Justice, admittedly in dissent, were very clear in saying at para 151 that the analysis of constitutional cases has to be guided by these types of unwritten principles. So we say relying on constitutional principles is nothing new or surprising. We say that theoretically we're on solid ground. The next question is whether the Act offends the principles of federalism, and we say it does because of the backstop, because of its uneven application across the country. There's not a lot of case law on this issue. I dare say that's because most federal legislation applies more or less uniformly across the country, and that's really the whole point of the federal government having jurisdiction in the first place. If something calls for different laws in different provinces, logic would dictate that that should be a matter for provincial jurisdiction. The other point that I would make is the Constitution actually provides a mechanism for the federal government to achieve uniformity with respect to laws dealing with property and civil rights. It's Section 94, hasn't been used for a long, long time, but the federal government can pass a law about those things for the purposes of uniformity, but that law doesn't come into force unless it's adopted by the province. They can't force unanimity or can't force uniformity. So there's simply no mechanism in our Constitution for the federal government to set minimum standards for matters within provincial jurisdiction. There's no provision in the Constitution that allows the federal government to fill in the gaps in provincial legislation or to respond when they don't think provinces are exercising their jurisdiction appropriately. Those powers simply aren't contained in our Constitution. Those matters are the responsibility of the provinces. If the federal government wants uniformity with respect to matters within provincial jurisdiction, it has only 2 ways to proceed. First, by agreement, and second, with money. Like with respect to health care, the federal government can insist on provinces meeting certain standards as a condition of receiving federal grants. So they have 2 ways of achieving this objective of uniformity. But steamrolling over the provinces is not one of them. Even the old power of disallowance in our Constitution didn't let the federal government step in and pass the laws that they thought the provinces should be passing. They could disallow provincial laws, but that was it. Now, my lords, my ladies, I acknowledge that there's statements in some of the cases, there's statements in textbooks that say there's no rule in Canadian constitutional law that federal legislation has to apply uniformly across the country. But I say we need to dig a little deeper. Is that the rule? Are there exceptions to the rule? Does it matter why the legislation doesn't apply uniformly? And the first place I look for answers to those questions is some of the old Privy Council cases. And I know one of the interveners say, we rely on way too many old cases, but I never apologize for relying on an old case. And the case that I think is tremendously significant is the Johnny Walker case. It dealt with the application of federal customs duties to property purchased abroad by the province of British Columbia. And the Privy Council held that those customs duties applied because they weren't taxes. If they were taxes, Section 125 would have applied and the province would be exempt. But the Privy Council said they were what we would call today regulatory charges. But the Privy Council was very clear in saying that those customs duties only applied to the extent that there was no partiality in their operation. I submit that those words must mean that the federal government couldn't attempt to collect customs duties from one province, but not another. They couldn't say, well, Ontario has a high enough price on booze. We're not going to charge customs duties in Ontario, but BC, their booze prices are too low. We're going to charge customs duties there. I think that's not, the Privy Council said that's not permitted under the Constitution. Now, my lords, when we get to the more modern cases like the Quebec secession reference, which emphasizes the principles of federalism, the Senate reference that emphasizes equality of the provinces and the federal government, we submit that what emerges from those cases is a principle of uniformity in the application of federal law. The notion that federal laws can apply in one province but not others simply flies in the face of notions of federalism. But I need to address a case like Sheldon S. And that was primarily a charter case, and it held that under the charter, federal laws don't have to apply uniformly across the country. And I'm sure it's a case that a number of my friends will say that sinks his argument. I don't think it does. We have to keep in mind what the court actually said in that case. It said that sometimes in a federation, it's necessary for federal laws to have different application from province to province to further the values of federalism. Well, I would submit that in this case, the application of the act in some provinces but not others doesn't further the values of federalism. It destroys those values. It imposes laws in a province that has expressly rejected the policy behind those laws, and it applies taxation measures in some provinces but not others. And also, we need to look at what the Sheldon S. case was actually all about. The criminal code provided that young offenders could take advantage of alternative measures where provided by the province. Ontario chose not to offer alternative measures, and the accused in that case launched a charter challenge over that. But the decision of the Supreme Court respected Ontario's decision. It didn't authorize the federal government to step in and provide alternative measures in Ontario. So we think Sheldon S. supports our position. A couple of the interveners have pointed to cases like Hydro-Quebec and Fertany as examples of where the federal government has set the boundaries for its criminal law by relying on provincial legislation. And they've said that's a precedent for the backstop. It's my submission that that's like comparing apples to oranges. The provisions in those cases respected provincial jurisdiction. They didn't provide that the federal government could overstep that jurisdictional boundary and exercise jurisdiction for the provinces. In the Fertany case, and I know a little bit about the Fertany case because I was actually counsel for the Attorney General on that case almost 30 years ago. The criminal code said that lotteries, including bingos, are illegal unless you have a license from the province. And that general scheme was attacked in the Fertany case. We supported the federal government that the legislation was valid, and the Supreme Court ultimately upheld it as valid. I would say that Fertany would only be a precedent for the Greenhouse Gas Pollution Pricing Act if the criminal code had went farther and said, well, what if in Saskatchewan they really don't like bingo, so they're not going to issue any bingo licenses? Then the federal government would step in and start issuing bingo licenses in Saskatchewan, but not in the other provinces where they do issue bingo licenses. Or maybe the federal government would say, well, you can issue bingo licenses, but you have to follow these uniform national standards when doing so. So we don't think that Fertany is a precedent for the Greenhouse Gas Pollution Pricing Act. My lords, my ladies, the other point with respect to the principles of federalism that I would make is I would refer the court to the legal opinion prepared for the government of Manitoba by Professor Brian Schwartz, which we've included in the record. And he talks about the principle of equality coming primarily out of the Senate reference and suggests that where federal legislation doesn't apply uniformly across the country, and that uneven application is based on an arbitrary decision, the legislation can be found unconstitutional. And we adopt his opinion but with one variation. If the court doesn't accept that there's a general rule of uniformity, as Professor Schwartz suggests, there can still be cases where the uneven application of federal laws across the country is constitutionally illegitimate. He says the key is looking at the legitimacy of the distinction. Our concern is that invites the court to get into weighing policies and weighing the merits. What we would suggest is that if there isn't a general rule requiring uniformity, that at least where the reason for the uneven application is the federal government second-guessing provincial decisions with respect to matters within their jurisdiction, then the law is per se unconstitutional.
Mr. McAdam, I had a question about that. I wondered what the status of that opinion was in the record.
Well, my lord, it's an academic opinion. I think the status of the opinion would be the same as the status of an opinion set out in an academic law journal or something like that. I don't think it has any greater or lesser weight than that.
Okay, thank you.
And to,
But it was an opinion prepared for the government of Manitoba by a private sector lawyer.
yes. And yes, I would say it's very similar to a journal article. That's the way I would describe its weight.
It's not a very flattering portrait of academics if it's similar to a journal article.
Well, I mean, I think having an article published in an academic journal is quite prestigious. So
So do I, but to pick up my colleague's point, an opinion prepared by a practicing lawyer for a fee is not quite the same thing as an article that appears in a referee academic publication.
Well, my lord, I would simply say that when you read the article, it's a scholarly constitutional piece. It's not a hired gun type of piece. That's my submission. And to wrap up on the federalism argument, what I would say is another way to look at Saskatchewan's position about the backstop is it's clear under our Constitution that the federal government can't step in and pass laws that it thinks the provinces should be passing. Isn't the backstop really just an indirect way of doing exactly that? Of the federal government enacting carbon pricing for Saskatchewan because the government of Saskatchewan is not doing it?
But don't you have to start in a different place, Mr. McAdam, or at least help me with this? Don't you have to start with the question of whether or not the federal law is otherwise constitutionally valid? It's in fifth and substance taxation, to take your view, or fifth and substance the national concern matter, to take Canada's position, and then ask the question whether there's a problem with it applying differently in some jurisdictions rather than others?
My lord, I would suggest the opposite approach, that you need to look first at the uneven application of the law across the country. And as we've said, that's really extraordinary, it's unprecedented. So what we would say is where you have a federal statute that applies unevenly across the country, that should be the first consideration. And that should be the consideration before looking at issues like, is this taxation, is this industrial regulation, those sorts of issues. So I think I would disagree with you, Chief Justice Richards, and say you need to approach that from the opposite direction. I next want to turn to Part 2 of the Act, and that's the part of the Act that sets emission limits for heavy emitters. And it's an issue that we think is plain and obvious. We perhaps didn't spend enough time on it in our factum. Part 2 clearly regulates business in the province. It establishes limits on how much greenhouse gases they can emit, how much business they do, the prices they charge for their products. In our view, that falls squarely within provincial jurisdiction. As Professor Hogg states in his textbook at page 20-2, and I'm paraphrasing here, ever since the Parsons case in 1881, it has been recognized that the regulation of particular businesses and trades in the provinces, and generally all matters related to intra-provincial trade, are matters within the exclusive jurisdiction of the provinces. In our submission, that's what Part 2 of the Act is all about. And here again, we would draw an analogy to the anti-inflation reference. Justice Betts, in his decision in that case, was clear in saying that the regulation of local trades and the setting of prices for products produced by local industries are matters that fall within provincial, not federal jurisdiction. And in Justice Betts's conclusion or view, it was the inclusion of the provincial private sector in that legislation that made it prima facie unconstitutional. And we say the same thing applies here. It's the inclusion of the provincial private sector, those industries that are usually regulated by the provinces, in Part 2 that makes it unconstitutional.
So,
No.
Mr. McAdam, if I might interrupt again,
Yep.
putting aside your federalism line of argument, is your position that Part 2 is properly characterized as a taxation matter, or does your taxation argument extend to Part 2 at all?
Our position is that Part 2 is industrial regulation with respect to industries and businesses within provincial jurisdiction. It's also our position that Part 2 imposes taxation and violates Section 53 of the Constitution Act. So we'll make both of those arguments.
Well, but if I ask you to clarify whether you're characterizing it in division of powers terms as taxation pursuant to Section 91 or as a regulation of local undertakings pursuant to Section 92, I mean, it has to be one or the other.
In our view, the legislation's pith and substance is the regulation of local businesses, local undertakings, matters that properly fall within provincial jurisdiction, and that eliminates the constitutional underpinning for the legislation without even having to get to the tax issue. So, my lords, my ladies, no one is disputing that the federal government could impose emission limits on businesses within the federal private sector, things like the aviation industry, the railway industry, the shipping industry, interprovincial pipelines. But it's extending this legislation to the provincial private sector that represents an overreach of federal jurisdiction and makes the law unconstitutional. This is a point that was made by Justice Laforêt in his dissenting judgment in the Crown-Zellerbach case, a case that my friend Mr. Jacobson will discuss in more detail, where he said even if Parliament's motive for enacting a law is preventing pollution, Parliament cannot constitutionally achieve this purpose by regulating local industries. That's exactly the point that we're making here. So in our view, Part 2 of the Act is clearly ultra-vires because of the inclusion of the provincial private sector, because it's not limited simply to the federal private sector. And my lord, the other point, my lords, my ladies, the other point that I would make with respect to that is I would refer the court to cases like the Natural Products Marketing Board case from back in the 1930s and the other cases dealing with the marketing of agricultural products. And I think one of the principles that comes out of those cases is even though something like potatoes might be exported, which would then fall under federal jurisdiction to deal with interprovincial and international trade, the fact that there are those extra provincial elements doesn't give the federal government jurisdiction to regulate the potato industry. And I think that that's a principle that applies here as well. My lords, my ladies, next I'd like to turn to the whole issue of whether Part 1 and Part 2 impose taxes or regulatory charges. And as I've said, it's Saskatchewan's position that the Act as a whole is unconstitutional no matter how it's characterized. But we also think it's important to deal with this issue of taxation versus regulation, primarily because of its importance to Sask power. But there are some other reasons. We have three reasons why we rely on the importance of this issue. First, if the charges that are being imposed by the Act under either Part 1 or Part 2 are taxes, well, the federal government has jurisdiction to impose taxes. Nobody's arguing about that. But that means we don't need to look to POG to find jurisdiction for the Act. POG is only required for federal legislation that would attempt to establish a regulatory regime that would extend to the provincial private sector. You don't need POG to tax. Second, taxation powers come with some very important limits. We've suggested as a general proposition that federal legislation that does not apply uniformly across the country should be constitutionally suspect. But even if the court rejects that argument as a general proposition, we submit that such a principle ought to apply to taxing legislation. The notion that the federal government can tax some provinces but not others is one that could lead to great mischief. It's easy to imagine a situation where a federal government is elected with support in one part of the country, not in another part of the country. Does that mean they can only tax those parts of the country where they don't have political support? That would surely be contrary to our Constitution. In this case, the fact that the Act and the taxes apply in 4 provinces and not the other 6 is said to be, well, it's a difference in policy. Well, I'd submit, my lords and my ladies, that the distinction between policy and politics is a pretty fine line. So what I'm suggesting here is this notion of being able to tax in some provinces and not others is a Pandora's box, and a very dangerous Pandora's box. Surely that's contrary to the most basic principles of our Constitution. I have a number of authorities to rely on for the proposition that when it comes to taxing legislation, at least, there must be uniformity. The first thing I rely on is a passage, it's referred to in our factum, from the textbook by Professor Laforêt, who later became a justice on the Supreme Court, on the allocation of taxing power under the Constitution. He says, the comprehensive reach of Section 91(3) indicates no limits should be imposed on the power except such as are clearly spelled out or inhere in the federal structure of our Constitution. And it's those last words that we think are important. Taxes can't be applied in ways that are inconsistent with federalism. Second, I've included a couple of cases in the supplementary book of authorities, and I acknowledge that there's some old cases that say there's no law that tax has to be applied uniformly across the country. But in Abbott versus City of St. John in 1908, the Supreme Court accepted for provincial and municipal tax that tax has to apply uniformly and without discrimination. Justice Iddington said in that case that the Constitution should not be interpreted in a way that creates inequality or injustice. In our submission, that applies just as much to federal tax as it does to provincial tax. There's also the decision of Justice Haldane in Minister of Finance versus Smith from 1926, which says that federal taxation should be applied on the same principles throughout the country and should not vary from province to province based on the particularities of provincial law. We say that's the same situation here. It's a principle that was highlighted by the Rowell-Sirois Commission report in 1939. It's reflected in an express provision of the American Constitution, Article 1, Section 8, Clause 1, and I acknowledge that American constitutional law principles are not directly transferable to the Canadian situation, but I think it's an important precedent to look at. And fifth, this principle is expressly set out in our Constitution. It's in Section 92A2 and 92A4, which authorize provinces to enact laws dealing with the export of natural resources and the taxation of those resources, as long as those laws don't discriminate or differentiate between provinces. So that's an express enunciation of this principle. Next, if this is taxation, Section 53 of the Constitution Act 1867 applies. That's the provision of our Constitution that embodies the principle of no taxation without representation. That's a tremendously important principle. It traces its origin back to the English Bill of Rights in 1688. In our submission, Section 53 requires that the essential features of taxing legislation be included in an act that's debated and passed in Parliament. Those essential features can't be delegated. The only thing that can be delegated is details and mechanisms. Here we rely on the Ontario English Catholic Teachers case from 2001, where the Supreme Court said at para 75, it's okay to delegate the power to set rates as long as that delegation takes place within a statutory framework that sets out the structure of the tax base, and the principles for its imposition. So we say fundamental decisions about taxation cannot be delegated, and particularly if there is a power to apply taxes in some provinces but not others, that is not a power that can be delegated. It has to be decided by Parliament. It has to be included in the legislation. My friend from Canada says, no, all that's required is an express delegation. Surely that cannot be correct. It cannot be the case under our Constitution that the federal Parliament can say to Cabinet, you can tax anyone at any time, for any reason, in any amount you choose, and that's okay. And that's express. You can't get any more express than that. It's our position that that makes a mockery of Section 53 and the principle of no taxation without representation. The other thing I would say about Section 53 is the case law is clear. If the federal government is purporting to delegate taxes, they have to say they're delegating taxes. They can't pretend it's something else like a regulatory charge. Finally, if this is taxation, Section 125 of the Constitution Act applies. That's the provision that provides that one level of government can't tax the other level of government. And it's relevant to this case in a couple of ways. First, to the extent that governments are being asked to pay the tax, and under Part 1, the tax applies to distributors, so where the province is acting as a distributor, like Sask Energy distributing natural gas, that tax is not going to apply. There will be nothing to pass on because it's a tax on provincial crown property.
Mr. McAdam, that's the key though, right? That's a question of applicability, not constitutional validity.
Yes, yes. With respect to Sask Power, Sask Energy, it is a question of applicability, not the vires of the legislation as a whole. But it's very clear our position at the end of the day, even if you reject everything else that I say, my lord, you're going to have to conclude at the end of the day that this legislation does not apply to Sask Power and Sask Energy because, among other things, it constitutes taxation of provincial property. And the other part of it...
Just to clarify,
yeah.
I guess I would have thought that that's something beyond the four corners of this reference because it's a question of the applicability of the legislation, not a question of its constitutional validity.
My lord, the reference case is drafted very widely, and it was drafted very widely deliberately, and it's my position that the reference case, as stated, includes issues of constitutional applicability as well as the vires of the legislation. That's my position. And with respect to Part 2 of the Act, it's our position that that is taxation as well, and to the extent that a Crown corporation like Sask Power is directed by Part 2 to pay charges for excess emissions, that too is a tax on provincial Crown property.
I thought you told me a little while ago that it wasn't taxation.
Our position is, first, it's regulating businesses in the province, and it's because of that overreach, it's unconstitutional. That's its pith and substance. In our view, that takes away the constitutional foundation. If you disagree with me on that, it's then my position that it's taxation and that it doesn't apply to the Crown Corporation. Now, with respect to the issue of whether this is taxation or regulation, it's Saskatchewan's position that these are taxes. It's not a question of semantics. It doesn't matter that they're called charges in the Act. And I think you could boil our argument with respect to taxation down to this. If it looks like a duck and it walks like a duck and it quacks like a duck, it's a duck. When consumers pull up to the gas pumps and buy gas, they're going to pay the charge and it looks exactly like paying the GST or the PST. There's no practical distinction between the charge and a tax. And when we look at the legal tests, I think it affirms that view. The Lawson case is the leading case on determining what's a tax, and it's a general test imposed by law, by a public body for a public purpose. Clearly, the charge under Part 1 and the charges under Part 2 meet that test. And I'm going to talk initially just about Part 1. And I don't understand the Attorney General of Canada to be disputing that the Lawson test is met. But she says, no, it's a regulatory charge. It's part of a regulatory regime because people are being disincentivized. The increase in price is going to lead people to drive less, so they will reduce the amount of greenhouse gases that they burn. And in her view, that makes it a regulatory charge, not a tax. And I would submit a number of things about that argument. First, I would say it's an argument that this court should not readily accede to because it gives the federal government an escape clause, an easy way to get around the constitutional obligations in sections 53 and 125. Those principles are too important to easily discard. You can't just say, voila, oh, this is intended to affect behavior, and therefore it's not a tax. Many, many types of taxes have revenue-raising purposes and regulatory purposes or an intention to change behavior. Tobacco taxes are the perfect example. And when I think of this argument, taxation versus regulatory charges, I can't help thinking, geez, King George III should have said to the people of Massachusetts, oh, don't worry, these aren't taxes. These are regulatory charges. I'm not taxing your tea. I just want you to drink less tea. We might have avoided a revolution. So my comment is the court shouldn't readily accede to the federal government's argument about finding a way around Section 53. If we look at the cases on regulatory charges versus taxes, one of the things I'll say about those cases is I think that sometimes the judges get a little too tied up in knots trying to apply legal tests, and they overlook the broader principles at stake. And one of the things I would emphasize here is you need to look at this from the perspective of the person being asked to pay the charge. The issue, as set out in the cases, is, well, if it's primarily to earn revenue, it's a tax. If it's primarily to regulate, it's a regulatory charge. And you need to determine which is predominant. My friend says it's intended to change the behavior of consumers. The first comment I would make is the charge doesn't even apply to consumers. It applies to distributors. You'd think if the government of Canada wanted to change consumers' behavior, they'd actually apply the charge to consumers, but they don't. And as Sask Power points out in its factum, it can't even pass charges along without going through a rate review commission. Second, is there a regulatory regime here? It's my submission there isn't. Consumers under Part 1 aren't told to do anything. They're not told to limit how much they drive or how high they keep their thermostat set in their house. They're simply being told to pay more money. And the federal government hopes indirectly that will have some impact on greenhouse gas emissions. So there's no regulatory regime associated with Part 1. Next, Next, we need to look at the revenue. What happens to the revenue that's earned under under Part 1? The Attorney General of Canada acknowledges at paragraph 115 of her factum that it's not used to offset regulatory costs because there are no regulatory costs. The revenues don't go into any sort of special fund. They're not used to fund green energy projects or to fund the move to a low carbon economy. No, it goes back into general revenues. And it gets returned to taxpayers as tax credits on their income tax. The federal government treats it like revenue. And the other point is when people are getting the money back, it's hard to see how they're really disincentivized to do anything. And what's particularly unusual about the scheme in this act is people are going to get their money back on their 2018 taxes before the charges are even in force and have been collected. Now, it's true not everyone's going to get the same amount back as they paid. So there's an element of the redistribution of income here, which we say, again, is a classic marker of taxation. And so everybody gets this refund back. You don't have to put solar panels on your house or buy an electric car to get the money back. Everybody gets it. There's no strings attached. You can spend it on whatever you want. So in our view, there is no regulatory regime associated with the charges under Part 1, and that simply having a goal of changing people's behavior cannot be enough to avoid the characterization of the charges as taxes. Now, with respect to Part 2, I admit that it's a little more complicated. There is a skeletal regulatory regime with Part 2. Companies caught by Part 2 are told to do something, limit your emissions. So our first argument, and to get back to your point, Chief Justice Richards, our first argument is that Part 2 is simply unconstitutional because it represents overreach of federal jurisdiction, because it includes the provincial private sector as well as the federal private sector. So we say that there's no constitutional foundation for Part 2. It doesn't matter whether it's taxes or regulatory charges. And here, my lords, I would point out that I think, with greatest of respect to my friend, inter factum, I think she talks out of both sides of her mouth at times. At paragraph 82, she says, Part 2 is not industrial regulation. Companies are not being told what to do. They just have to pay the charge, and then they can figure out how to avoid it if they want to. But then beginning at paragraph 114, where she's talking about taxation versus regulatory regime, she says Part 2 is a complete regulatory code that applies to heavy emitters. And of course, she has to make that argument to avoid the characterization of the Part 2 charges as taxes. Well, she can't have it both ways. If it's a tax, it runs afoul of Section 53. If it's regulation, it runs afoul of Section 92. But even if we assume that the regulatory regime itself in Part 2 is somehow constitutional, that doesn't necessarily mean that the charges are regulatory ones and can't still be characterized as taxes. Even in the cases where there's an established regulatory regime, charges will still be characterized as taxes if their primary purpose is to raise revenue. And that's what we say is the case here. There is a skeletal regulatory regime, but that's all. People don't have to get licenses under Part 2 of the Act. They have to register in order to get their credits, but there's no licenses for these companies to operate. So that component of a regulatory regime is missing. As far as the mechanics, there's really no regulatory agency created here to oversee how these companies do business. As my friend says, it's up to them to figure it out. All they have to do is pay the charge. So the mechanics that are set out in the Act at great detail, they're not about regulating, they're about how to collect the charge. That's what they're about. They're tax collection, and that's why the Minister of National Revenue is given the authority to do it. And fourth, and I think this is the most important point, regulatory charges are usually tied to the costs of regulating. The monies are used to offset those costs, or they're devoted to a regulatory purpose. In this case, they go into the Consolidated Revenue Fund. The Attorney General admits in her factum that the charges under Parts 1 and 2 of the Act will bring in substantial revenues. She admits that those revenues aren't calculated in any way to offset the costs of the regulatory regime because there is no regulatory regime. She admits that when it comes to spending those revenues, the federal government has complete discretion. Part 1, they'll pay back to consumers. Part 2, she says in paragraph 59 of her factum, the federal government still really hasn't figured out what they're going to do with the money under Part 2. But it's going to go to support schools and hospitals and small businesses and municipalities and indigenous communities. Typical government expenditures, not tied to a regulatory regime. And then what I found most shocking is at paragraph 118. the factum says, well, these charges are intended to alter behavior. So it really doesn't matter about costs of regulation or how much revenue is brought in. It simply doesn't matter. It's not a tax. As long as the federal government says we're trying to alter behavior, none of those principles that apply to tax apply. My lords, my ladies, it's my submission that that cannot be the way to interpret the taxing powers in our Constitution. And my lord, my lady.
At least for my purposes, could you show me, take me to the provisions of the Act that, that speak to how the revenues collected under both Part 1 and Part 2 are to be put back into the world?
My lord, I do not have those provisions of the Act committed to memory in enough detail to be able to answer your questions. I know it's a matter of discretion, and I've referred to the provision in my friend's factum, but as far as quoting you, it's this section or that section of the Act, I can certainly get that information to you, but I can't give you that on my feet today.
Well, you can maybe make a note of that for the reply if counsel for the Attorney General of Canada doesn't assist on that.
Absolutely, my lord. The last case that I would mention before I turn it over to my friend, Mr. Jacobson, is on this whole issue of whether something is a tax or a regulatory charge. The fact that there's a regulatory regime in place is not conclusive. The levies within that regulatory regime can still be taxes if they're considered to be money makers, revenue makers. And a case that I think supports that position is reference re-exported natural gas from back in 1982. And that was a case that dealt with a federal tax on natural gas that was found to run afoul of Section 125 of the Constitution Act 1867. But there was a regulatory regime in place in that case, and the court even acknowledged that the tax was going to increase the price of natural gas and thereby reduce demand. But when they looked at the revenues, in that case, it was a revenue maker. It was a money maker. The levies didn't have anything to do with the actual regulation. And it's our view that the same thing applies to Part 2.
What is the significance, Mr. McAdam, of the fact that this is not a scheme that raises revenues for general purposes?
It does raise revenue for general purposes, my lord. That's our understanding of the Act.
You'll have to, you can't answer that question without showing me the sections of the Act that govern how those fees.
And my lord, I don't have the section of the Act at my fingertips. I don't understand that my friend from Canada is objecting that, or taking issue with the submission that these are monies that go into the Consolidated Revenue Fund. No.
Right, but if they all have to be paid back out for a particular purpose, it's somewhat different than if they just go into the Consolidated Revenue Fund and can be used for anything and everything. And that's the clarification I'm looking for.
Yeah, and my lord, I think with respect to paying out all or a part of the monies collected, my understanding is the announcements that the federal government has made are that they will be paying all of the money back out. It won't go back to consumers exactly in the amount that they paid in, and that's with respect to Part 1 for consumers. With respect to Part 2, they haven't made that commitment. My understanding is it's not a commitment to pay all of the money back out. But quite frankly, my lord, my position would be paying the money back out to things like hospitals and municipalities and Indigenous communities may very well be a noble purpose, but it has nothing to do with regulating greenhouse gases. It's just an exercise of the spending power. It doesn't make the money anything, doesn't make it a regulatory charge, doesn't change the characterization of the tax. With that, I'll turn it over to my friend, Mr. Jacobson.
Perhaps this would be, I think my colleague has a question, and then when we're done with that, I think it's likely an appropriate time to take a morning break.
Mr. McAdam, earlier on, you talked about there being an analogy between this legislation and the New Deal legislation. And in particular, you mentioned the unemployment insurance reference. Were you going to talk about that a bit more, drawing comparisons to it? What is the analogy that you wanted to draw there?
I wasn't planning to talk about it in any detail, but what I would say, my lady, is that we see the analogy between unemployment insurance, the Great Depression, the economic disaster that the Great Depression was, the unemployment that existed. And one of the things to be a constitutional law lawyer, you also have to be interested in Canadian history. And the Bennett government decided in the 1930s that they were going to enact legislation to establish a national system for unemployment insurance. When the Mackenzie King government was elected in 1935, they referred all of that legislation to the Supreme Court for an opinion on its constitutionality. The Supreme Court struck it down, the Privy Council struck it down, and they struck it down for the same reasons that we're relying on here today, that was legislation that dealt with the relationship between employers and their employers in individual businesses within the provinces. It was matters of property and civil rights within the provincial jurisdiction, and that it was an overreach of federal jurisdiction, no matter how important the issue was. And the other thing I would add with respect to the New Deal legislation and unemployment insurance in particular, in order to get the unemployment insurance scheme we have today, it required a constitutional amendment.
Thank you. I take it that you would say that the result in the Privy Council decision in 1937 is of significance here in the analysis of this legislation.
Yes, we really think the analysis is parallel. It's on all fours. It's very similar with respect to the reach to matters within provincial jurisdiction, and that the crisis of the Great Depression did not warrant the federal government taking those steps.
Mr. McAdam, I have a question on your argument that federalism is a freestanding principle which would render the act unconstitutional. Are there any cases where that has specifically happened, where it was used as a freestanding principle before you ever got into the pith and substance argument?
There are cases dealing with the federalism principle. I've referred in our factum to a case like the Prince Edward Island judges cases, the Manitoba Métis Federation case, the secession reference, those cases where the Supreme Court has relied on principles to aid in interpretation, to fill in the gaps in the Constitution, and that's what we're asking to do here with respect to the principles of federalism that were recognized in the Quebec secession reference as one of the four foundational principles. Now, I can't point you to a specific case that's relied on the principles of federalism to do what we're asking the court to do today, but certainly there are precedents with respect to other principles.
All right, Council, I think we'll take a 15-minute break, and we'll return to hear from you, Mr. Jacobson. So let's make it 15 minutes sharp, everybody.
Please rise.
May it please the court, I am proposing to address the claim, as mentioned, that the Greenhouse Gas Pollution Pricing Act, which I'll refer to as the GGPPA, or the Act, is authorized by the Peace, Order, and Good Government power under Section 91 of the Constitution Act 1867. To begin with, I wish to emphasize the court's proper concern in this question. The court's concern is to protect the Federation, not the environment. The legislative branch looks out for the environment and takes into consideration a myriad of factors. The courts are not equipped to do this, and moreover, it would be anti-democratic for the courts to side one way or another on the importance of the particular measures in question. No matter how laudable or critical the federal government's initiative may be said to be, this can have nothing to do with the question of whether they have the power to do so. Nothing less is demanded by the rule of law upon which our Constitution is based. And you might have noticed that I've already referred to two more of the main unwritten principles that we read of in the Quebec Secession reference, in addition to federalism, democracy, and the rule of law. I'd like to address another potential pitfall that relates to the notion that Saskatchewan might be suggesting that the kind of measure being proposed cannot be implemented. This is false. The scheme being proposed is entirely within the ability of our Federation, each head of government, each level of government working within the scope of its own powers. Our Constitution leaves no gaps. We argue that jurisdiction over the subject matters in question are not concurrent between federal and provincial governments, but this in no way prevents the governments, when acting within their proper spheres, from establishing a scheme with the identical mechanisms as those established by the GGPPA. I'd like to address this a little bit later under the theme of cooperative federalism. You've heard Mr. McAdam explain that the measure in question is an attempt to introduce a tax, no matter how it might be described. The federal government reluctantly relies on its taxation powers in the alternative. They just mentioned this very briefly at the end of their factum. They are at pains to insist that the GGPPA does not introduce, in fact, a tax, but that it introduces a carbon pricing scheme that is authorized not by the federal taxation power, nor by any other power other than the Peace, Order, and Good Government power, which all from here on refer to by its common abbreviation, POG. So it's my task to examine the question of, assuming this is not a tax, what kind of measure could it be, and could it be authorized by the POG power? In so doing, I will mainly examine the question from the federal government's, indeed from the Act's description of the nature of the measure. This in no way is to derogate from Mr. McAdam's observations this morning. Instead, it's an exercise in exploring what would the consequences be were we to accept the hypothesis of the federal government. Where would that take us at face value in terms of division of powers? A final important introductory observation that I wish to make is that when it comes to seeking to justify Parliament's powers to introduce the GGPPA, deference should be made to the federal government in how it seeks to justify the Act. It's notable that the federal government is very specific about this. They rely on one alternative power, which they do not wish to rely on, but do not rely on any other power. Many other theories have been introduced by intervenors favorable to Parliament's authority to introduce this Act, including the criminal law power, power over interprovincial trade and commerce, and the emergency power of POG. Much may be said in response to those theories. We choose, in the time and space allotted, to particularly focus on those grounds that the federal government relies on. And despite the various the efforts of various intervenors to rescue the Act on behalf of the federal government, we submit that the court should be reluctant to impute to the Act justifications that the government does not wish to rely on. And I would suggest that there's a reason why they take this strategy. They'll speak for themselves, of course, but the Act and its justification is transparent enough for us to make a certain amount of observations. The POG power is sweeping in nature. It is a displacement power. It's radical and intrusive. Once accepted, it's absolute and exclusive. This is what the federal government wants for the GGPPA. It wishes to displace provincial space that today exists over these areas. And it wishes to do so without being trammeled with the limitations of other powers that would leave it less room to act with the kind of sole flexibility that it wishes to use. For example, the criminal law power, we know that it has several inherent limitations. For a measure to be justified as criminal law power, it must have a valid criminal purpose. It must be based on a prohibition, not a regulatory scheme. The trade and commerce power, for example, we know is limited. It does not extend to schemes that are primarily involved with intra-provincial trading. The emergency branch of the POG power, another one that you'll hear a little bit about, is necessarily temporary. This is also a limitation that the federal government does not wish. It wishes to have absolute, uninterfered with space over regulation of greenhouse gases. None of these less absolute, sweeping, and exhaustive heads of power, which more naturally would fit, will do for the federal government. And in this connection, I'd like to speak very quickly about the double aspects doctrine that you heard a little bit about and you'll hear more about, I suspect, tomorrow. The double aspects doctrine, as Mr. McAdam said, should not be a tool for allowing the divisions of powers to bleed together. There is a room for the double aspects doctrine. It is necessary in our federation. A good example might be highway traffic. We know that it is primarily regulated by the province, but we also know that in part it is disciplined by the federal government using its criminal power. Does this mean that they have concurrent jurisdiction over the same subject? No, it does not. It means that highway traffic is not a head of power, but that in its regulatory, the regulatory necessities of controlling highway traffic, we see that as primarily a provincial domain, but we also see that some behavior must be prohibited by criminal sanction. The same thing can be said with respect to environmental law. And the cases are very clear on this. We know from Hydro-Quebec and other decisions that the environment is not an exclusive jurisdiction for either head of government, but instead that there are aspects for each level of government to control. And we know historically that the provinces have dealt with the question, the very questions that the GGPPA deals with. Industrial regulation, limits on the kind, and the disciplines over the kinds of industrial emissions from factories. But there can be criminal law aspects to environmental controls as well. We know that from Hydro-Quebec, provided that it's truly done with the criminal law power. Federal government wants none of that. They want to have an uncomplicated, exclusive space over greenhouse gases. That's the inescapable conclusion. That's the gambit. The courts, of course, must be very suspicious of this kind of radically centralizing displacement. And make no mistake about it, it is a displacement of provincial authority. I'd like to illustrate this a little bit. Let's take an easier example, that of aeronautics, justified under the POG National Concern Branch. It was found to be it was authorized under the POG. This meant that Parliament, and only Parliament, could regulate aviation, whether that involved a network of international flights crossing several provinces, or a single farmer dusting his crops at low altitude. Exclusive federal jurisdiction because of the POG power. No double aspects. And in the case of aeronautics, it's worth noting that we had the introduction of a new phenomenon. That's why we didn't need, for example, or it was easier for the Federation to accept this recognition rather than insisting on a constitutional amendment. Airplanes were new. The displacement of provincial jurisdiction was less disruptive for that reason. But it was a displacement. Air travel, just like vehicular travel within the province, would have been a provincial concern, but for the POG national concern power. You could say the same thing about nuclear power. In the case of greenhouse gas emissions, we are not talking about the development of new technology, as is the case with aeronautics, nuclear power, or broadcasting. Pollution control has been in the interest of governments from before Confederation and has been regulated as such, sometimes by criminal law, sometimes, most often, through industrial regulation. I think early on there was the notion that it could be dealt with in terms of nuisance law, as for private remedies there as well. But it was never understood as a matter that must be regulated exclusively by the federal government. Justice Betts, in the anti-inflation reference, dealt with the question of whether the containment of inflation should be justified under POG. He was in the minority on the emergency power basis, but his analysis of the national concern branch of POG was the majority decision on that aspect, and it remains the leading seminal case. And this is made clear in the Crown-Zellerbach decision as well, where Justice Ledane reviews Justice Betts' opinion, recognizing that it is the leading decision. In the course of his reasons, he observed that inflation was, quote, a very ancient phenomenon, several thousands years old, as old probably as the history of currency. The fathers of Confederation were quite aware of it, end quote. The same point may be made here. In our materials, we show that air pollution was regulated in England prior to Confederation. The various types of pollution, the various consequences may change over time, but absent a genuine interprovincial interference to be discussed later, there is nothing new under the sun. The fathers of Confederation were quite aware.
Is the fact that there's been a recent recognition of greenhouse gas emissions literally imperil the future of the planet? Does that put things on a different footing than the footing that the historical regulation of pollution might have been on?
Yeah, the most that can be said is exactly that. And it is said by several of our friends opposing us today, that it's our understanding of the consequences of greenhouse gases. That is what is new. That's what justifies this displacement of provincial power. And with respect, we would say that it's not the changing of priorities. It's not the development of scientific understanding of regulatory consequences that allow for the shifting of power from one government to another. And I would add to that also that we have known about greenhouse gases for longer than it's become surfaced as the primary political issue of the day. This is something that's been understood and explained for many, many decades. It is true that the importance has grown rapidly in the last several years. But I would say this is very different from the introduction of a new phenomenon. When Professor Hogg writes on the subject of the POG National Concern Branch, he draws that category of genuinely new issues. And that can be seen as a category of cases, which I attempted to describe a little bit earlier. And we think it would be very important, and it would be a damaging, a subtle but damaging doctrine to say that, well, we never realized how critical, how important this pollution was. This is far more important than we ever thought it might be. And now, because it's reached this level, only the federal government can be trusted to contain it. And incidentally, I would say, my lord, to your question, that an understanding of how critical it is, there's a subtle implication or suggestion from our friends opposite that when something can get to a level of importance, that's a point at which the federal government can be justified to take over. And we say that the POG National Concern cases do not establish that. It's one thing, and we'll get into this, I wanted to get into this a little bit later, but the National Concern Branch, one of the critical tests of it is to say, is there actually a provincial inability with respect to this test? So with your permission, my lord, more about that a little later. And so, just to repeat, we say that the agenda of this act is to take over exclusive control. And the problem with this true agenda is that it is actually self-destructive. We know already that the official opposition in Ottawa has pledged to repeal the GGPPA if they are returned to power. So the irony is that if the federal government is right, that this act must be a part of their POG power, not only would the GGPPA measures be removed, but provinces would be unable constitutionally to fill the vacuum. Today, certain provinces are going down this road, are doing the very things that the federal government wishes the provinces to do. British Columbia is the obvious example. This further illustrates how important it is for this court to take the long view of the question and answer it according to constitutional principles instead of breathless warnings. Those warnings are heeded or not according to the wisdom of our elected officials acting within their respective authorities. This point also illustrates the strength of our federation, where politically it is desirable for some provinces to sacrifice industrial strength or reduce consumer spending power because of countervailing environmental judgment, they do so. That is democracy. Again, another of our foundational constitutional unwritten principles. If diversity is strength, then the various provinces, each dealing with the claims of climate change according to what suits its own environment and its own economy best, is the most promising model. An all or nothing Ottawa way is far less stable in the long run. And at the risk of repeating myself again, it's also disrespectful to the sovereign authority of the provinces that this suggestion, they're too small, they're too untrustworthy. It's an anti-democratic reflex. Now, several times I've insisted on the exclusivity of the POG power when describing it. This is consistent and a necessary quality of the POG power. And although I've endeavored to show that it is rational for the federal government to seek this absolute displacement of power, they, or at least some of the intervenors, wish to soft pedal this absolute displacement, this new exclusive power. But the Supreme Court cases, including the Crown-Zellerbach case, do not brook the notion of POG powers being shared with the provinces. And so the federal government wishes to have its cake and eat it too in this respect. The power is exclusive so that Ottawa chooses the national standard for every jurisdiction. But then the Act turns around and recognizes provincial jurisdiction to choose and implement the national standard at its own limited discretion, according to the discretion to meet the approval of the Governor General and Council. And by the way, it's akin to some kind of theory of limited delegation. And we know that delegation between federal and provincial legislatures is constitutionally impermissible. There's no apparent solution to this problem of exclusivity. It's curious, moreover, that the federal government wishes to drive the GGPPA into this collision. It sounds like hyperbole to state that if the federal government is right, then British Columbia and the other provinces can no longer regulate in the area of greenhouse gases, but that is actually the case. So I suggest to you that the GGPPA brings this cloak of recognition of sovereignty that you can read of in the preamble as a means to try to hide this drastic effect. The legislatures are sovereign in their areas of jurisdiction. This basic tenet of our federation was underlined in the recent Pan-Canadian Securities Regulation reference that the Supreme Court released just a few months ago. Our federation does not contemplate a province having sovereignty provided that sovereignty be exercised to the satisfaction of the federal government. That is totally foreign to our system. One of the interveners is inviting you to cast aside provincial sovereignty in favor of centralizing whenever an international treaty is at stake. And that you should set aside the basic integrity of our federation that was affirmed in 1937 on this point. That same Supreme Court decision of last fall affirmed, cited the Labor Convention's case with approval. It's not a fusty old case that must be forgotten. And the reason for that is because Ottawa is not a big brother jurisdiction over the provinces, even when it makes international commitments. And obviously, the opposite conclusion will definitely mean an endless erosion of provincial powers, is if all it takes is for an international treaty to override them. And incidentally, on that point, even if it were the case that the country were bound by the Paris Agreement, the agreement does not require carbon pricing of any kind. The strategies to achieve the goals of emission reduction are left to the discretion of the countries. Again, Ottawa must seek to implement the goals in coordination with the provinces when it comes to their jurisdictional powers. A finding of POG jurisdiction, especially over an area that is not new, is a radical constitutional shift that should be recognized only with the greatest reluctance and a full appreciation of the constitutional questions. The jurisprudence requires great caution. In that respect, I'd like to read a quote that we printed on page 4 of our factum. And this again goes to the question of, well, after all, you know, are we just relying on those outdated old Privy Council decisions that, you know, in the era where people like to describe our federation as a ship with watertight compartments? Well, we see that in Crown-Zellerbach, the Crown-Zellerbach case itself, Justice...
Which factum are you referring to?
This is our reply factum, my lord, from dated, I think, in November.
Yeah, got it.
Thank you.
Paragraph 4?
Page 4 is where you'll see Justice Ledane quotes Lord Watson from 1896. this is a fundamental point that remains important. It's a point that was repeated with importance by Justice Betts, and here it's being repeated again in Crown-Zellerbach by Justice Ledane. And the point is that this was understood in 1896. Lord Watson says, great caution must be observed in distinguishing between that which is local or provincial, and therefore within the jurisdiction of the provincial legislatures, and that which has ceased to be merely local or provincial and has become matter of national concern in such sense as to bring it within the jurisdiction of the Parliament of Canada. It's critically important that the courts move in that direction with great reluctance, great caution, great suspicion. The caution that is required can be underlined by considering the effect of a finding of national concern, POG, over an area hitherto recognized as provincial jurisdiction. It really amounts.
Mr. Jacobson,
yes.
you are going to come to the nitty-gritty of singleness, distinctiveness, and impact and so forth.
Yes, my lord. I'm going to review those in fairly briefly in the time allotted, and with some general remarks. We rely strongly on our written material. I didn't wish to repeat that in my oral presentation, but I certainly am interested in fielding questions on that area. But there are some things that we feel are important to state, the general principles. And our approach is a little unusual in that way, recognize, but this really is a case about first principles. So that's why we're taking some time in that direction. I won't repeat what Mr. McAdam said about constitutional amendment being the appropriate way to shift something from clear provincial room into federal. We have examples of that: old age pensions, unemployment insurance, etc. So am I suggesting that there's no room for POG national concern? Not quite. I gave you the example of aeronautics. I say that is an example where the court said cautiously, carefully, this is something that we can recognize. It's genuinely new. But with your permission, I'd like to turn now to the question of cooperative federalism, because we think that is key in the proper solution to this problem.
Before you leave this, are you saying then that POG power can never be used in a situation where something local or provincial has become something of more national importance?
That's an excellent question, my lord. And what I would say about that is that, in the first place, there's a very subtle potential misunderstanding about what we mean when we say national concern. I was going to get to this later, but let's talk about it now. The word concern itself has two meanings, and one denotes a certain sense of anxiety, and another one is simply a relational word. So you could say, for example, David Suzuki is concerned about the environment. The other meaning of the word would be, to give another example, I could say, I read the decision of the Court of Appeal concerning division of powers. The term national concern is a formal term of art in the second sense of the meaning of the word concern. And so it is very true. We would be the last to deny that the nation should not be concerned about climate change. Of course it should be. Is it a national concern? Of course. It's a provincial concern? Of course. It's a local concern, it's a global concern, it's an individual concern. But that's not the sense in which a provincial power can become a national concern. It's not about the degree to which the nation is worried, concerned about something. That's not a constitutional test at all. Instead, and again, I think what's helpful, my lord, is the provincial inability test, as explained in Crown-Zellerbach. I'm not sure if I'm answering your question.
Well, you keep coming back to it's not something new. You use the aeronautics example. And, I mean, if you're not saying that it's, the POG power is only restricted to new things. I just want you to make that clear.
I would say, my lord, that a review of the POG cases, you will see a limited amount of them. Some are better, some are worse. And I would suggest to you that the best understanding is that when it comes to matters that are not new, the overwhelming weight of the Supreme Court and Privy Council jurisprudence is that is not when you just simply flip jurisdiction. That requires constitutional amendment. And so newness really is a proper, legitimate way of recognizing, but even that should be limited, should be used cautiously. And again, just at the risk of repeating myself, we say this is not new, a new phenomenon. And our understanding of the consequences, which is still developing, does not make it new. And so if it's, with your permission, I'll talk a little bit about cooperative federalism. Again, this is the theme that was emphasized in the very recent decision of the Supreme Court in the Pan-Canadian Securities Regulation reference. I said earlier that it's not the case that we're trying to hearken back to strict watertight compartments in a way that recognizes, that fails to recognize subtleties. What we say is that the greatest of flexible and creative arrangements begin with a respect for each other's jurisdiction. And that's what happened in Pan-Canadian Securities. Cooperative federalism does not mean blurring the lines between heads of jurisdiction, allowing courts to move one way or the other in order to suit the political demands of the day. And so in Pan-Canadian Securities, we're reminded that the confidence that we have in clear jurisdictional boundaries, which were determined in the earlier case on securities from 2011, that's an understanding of those clear boundaries is what allows the governments to cooperate. And so the Supreme Court found that an arrangement which allowed for a common regulator to be appointed by agreement did not threaten legislative sovereignty, nor could it. The point is that good fences make good neighbors. The GGPPA could be commended for recognizing provincial jurisdiction, as it does in its preamble, to recognize provincial jurisdiction to deal with a widely perceived problem in its preamble, but it's meaningless to call the GGPPA cooperative. The backstop is not cooperative. It's coercive. Coercive federalism is the opposite of cooperative federalism. And to call this cooperative would be Orwellian and makes the notion of cooperative federalism meaningless. How could cooperative federalism work then in this context? Earlier, I emphasized that there's no gaps in our Constitution. Each level of government is able to legislate within its own respective jurisdiction. There's no matters, there's very limited 4 areas that Mr. McAdam pointed out of concurrent jurisdiction. There's several areas of exclusive jurisdiction, and there are large subject matters over which various heads of government have jurisdiction to deal with according to their respective spheres, including the environment. If we know that all things are possible, including a GGPPA kind of system, but that the significant details of such a scheme are within provincial power, then the key word of a cooperative federalism solution is one that is truly cooperative. And that's something that's hard for the centralists to accept. This was the key to the Pan-Canadian Securities Arrangement. It was voluntary. Does that mean the death of the Paris objectives? Not at all. It simply means that Ottawa may not run roughshod over the province's jurisdictional space. Ottawa, if it wishes to make international commitments involving matters within provincial legislative jurisdiction, then they bear the burden of persuasion. And that's not asking too much. Voters and candidates must persuade each other concerning the challenge of climate change. Countries attempt to persuade each other with varying success. Provinces may seek to persuade each other, and in Canada we have a federation which this court is duty-bound to protect. And in a federation, one jurisdiction must persuade the others on the question of jurisdiction. That's cooperation. And we've come close, apparently, very close. But it's not close enough for the government's liking, the federal government's liking. And that reflects not a constitutional infirmity, but a failure in persuasion on the part of the federal government. And if the failure results in coercion instead, that's not cooperative, that's serious injury to our federation. Let's turn then to the POG test. In the first place, I wish to address there's two branches of POG, the emergency power and the national concern power. One of the intervenors today is suggesting that this court should accept the validity of the act on the basis of the emergency power branch. I've already explained why we're not addressing that in great detail today. Parliament does not wish to, or at least the federal government does not wish to rely on that justification. I suggest there's two reasons for that. In the first place, it acknowledges too explicitly that it is a displacement of provincial powers. And in the second place, and more significantly, because the emergency power is necessarily temporary in nature. That's not good enough for the GGPPA. The only other thing I want to say about the emergency power is that we observed that Canada's factum, fully half of it, is dedicated to establishing what we say are irrelevant claims about the seriousness of climate change, the consensus concerning climate change, the causes of climate change, particularly that of carbon emissions, the effectiveness of carbon pricing as a solution, the ineffectiveness of alternative modes, such as direct emission reductions, etc. Now, Saskatchewan does not agree or disagree with any of these claims, but we note that they are policy questions of no constitutional relevance in a POG national concern test. They might have some value in an emergency branch test. And as we reviewed, even the fact of an international treaty is of no direct constitutional relevance. Ottawa does not want a temporary tax. The federal government has labeled carbon dioxide as pollution and intends to tax it or punish it permanently. So the question then is the fit of the national branch of of POG, which I will be talking about in the remainder of my remarks when I use the term POG. The Crown-Zellerbach decision, summarizing the earlier cases and particularly the Betts judgment, found that for POG to avail, the potential matter must be single, distinctive, and indivisible. It must be clearly distinguishable from matters of provincial concern. And it must be reconcilable with the fundamental division of powers. That it must respect provincial powers under our Constitution. It is none of these things. And particularly on those last two elements that I mentioned. It is not clearly distinguishable from matters of provincial concern. It is entirely a displacement of matters of provincial concern. It is not reconcilable with the fundamental division of powers. It is destructive of the fundamental nature of our division of powers. And then the final test, it's a subtest.
You're going to come back to these in some more detail, right?
At your wish, my lord.
I'm just trying to not interrupt if you're just outlining what you're going to cover in the next 23 minutes.
Please feel free to interrupt. I don't want to spend a great deal of time looking at parsing the Crown-Zellerbach case, but I'll do that as much as you like. There's some important things that I wish to say still about POG in general, and about the test. And what I was about to get to, my lord, is the provincial ability test.
Well, for example, on the question of distinctiveness, I'd be interested in your submissions as to why the regulation of greenhouse gas emissions is not distinct.
We would say in the first place that the act itself is too broad and general, but that what is more important is the nature of the power that's being carved out. So while the GGPPA helps us to understand what it is the goal of the federal government to do, we have to know, and that's the challenge of the court, of course, we have to, and this, I think what you're asking, my lord, is a question about pith and substance a little bit.
Well, I'm asking for your submissions on the application of,
Yes.
the, let's call it the Crown Delegate.
Yeah. Okay, well, I'll attempt to do that, my lord, and I certainly welcome questions. We say that POG does not fit the GGPPA, and we do rely on our factums for that explanation. I want to particularly commend the factum of New Brunswick on the question of, the distinction for Crown Zellerbach. We thought that was an excellent analysis. But what we are saying is that in terms of distinctiveness, we're saying that the act is far too large and broad and indeterminate. And we have the federal government saying, well, it just happens to relate to these chemicals that are identified right now in the act. But the requested new room of power that we're writing into Section 91 isn't going to necessarily, unless this court says it is going to be necessarily, confined to these particular chemicals. I don't think that's realistic. I think the moment that the scientists tell us that there's all kinds of other chemicals that are equally damaging, that list is going to grow rapidly. And pretty soon it will be the case that the protection of the environment is an exclusive federal jurisdiction. That's the necessary conclusion. And we already know that that's not. Justice Lafray has warned us against that conclusion, of course, in Hydro-Quebec and other places.
Isn't greenhouse gas emission something that's separate and distinct from mercury pollution or, the variety of other kinds of...
No, you can make distinctions, and lawyers and judges are great at making distinctions. But I would concede this much, my lord. As far as the tests for meeting the POG test go, we don't think that singleness, distinctiveness are the most fatal flaws of why POG does not meet this. You could argue this way. I think both sides. We would like to persuade you that they do not meet this test, but we would like to emphasize that the worse, the more egregious violation of the POG tests are those in the requirement about reconciliation with fundamental division of powers and the distinguishability from matters of provincial concern. And I would like to illustrate that point, my lord, if it's at all helpful, in thinking about the facts of Crown Zellerbach. And to do that, I'd like to begin with the interprovincial cooperatives case. And we think that case is really easy to understand, and it's a great way to highlight the problem of the Act. So in interprovincial cooperatives, we have a problem. We have the province of Manitoba unable to deal with the results of pollution coming downstream in the river. And they have no provincial ability to control that. And so the courts say, this is a matter of national concern. Why is it national? Why does it concern the nation? Because the province cannot do this on its own. We say the same thing with Crown Zellerbach. That's a case dealing with marine pollution. It was a close decision. It was a 5-4 split, if I remember correctly. I believe Justice Betts was in the minority, and it doesn't matter. That's our binding authority on the question of marine pollution. But the point I wish to make is that it was close to the line, and it dealt with, the reason why it was accepted is because it dealt with pollution in international waters. And they made the distinction about fresh water and salt water. They said that we can cut it off meaningfully there. All fresh water eventually, I mean, unless we're talking about Manitou Lake, all waters eventually get to the sea. But that's not enough to find it to be of a national concern. There's a limit to that. If it's primarily within the province that you're dealing with something, industrial emissions, the price of gas, the price of heating your home, those are not by any way could be described as being concerning the nation because the province is unable to do something. And that really highlights the main problem, my lord, here is that what is being characterized by particularly Canada and particularly BC is that the concern that's being drawn for you, and this is also a pith and substance issue, is that, well, it's not the subject matter of pollution control as such, it's the ability to have a uniform standard of emission control. That's a policy question, not a room for legislation. And so you don't begin by saying, well, because there must be a uniform solution, therefore the nation must have jurisdiction. That's leading the question, or begging the question. I'm just skipping over some of the things that I've said now, trying to say out of order a little bit in response to questions, so I'll get my bearings. Just want to follow up one more time with my comments on international treaties. And you'll be urged to say, well, you know, there gets to be a point maybe where we can't allow provinces to defeat international global initiatives. Canada is very experienced with the way this works. Whenever they negotiate an international treaty, they know that they do so at the peril of non-implementation by the provinces over their respective heads of jurisdiction. And so they understand the burden of persuasion, and they negotiate with the provinces in concert to have a common understanding of the commitments that they're going to make so that they have the confidence that once the treaty is entered into, it can also be meaningfully ratified through legislative implementation where it belongs among the respective jurisdictions. So just to return to what I think my friends opposite wish to argue is that, well, let me ask the question, how does an Ottawa policy turn into a national concern? You're offered the argument that somehow Saskatchewan does not tax its consumers at the ordained rate. The total emission targets Canada has set will not be met. Let's assume this is true. This still does not transform an Ottawa policy into a POG power. We're told that the greenhouse gases that Saskatchewan emits will damage the non-neighboring province of British Columbia. This is very, very different from the interprovincial cooperatives case example, or the Crown-Zellerbach example, where we have polluting molecules crossing a provincial border into the international sea, into a neighboring province. What we have in this case, and this is not a matter of controversy, this is clear from Canada's record, This is about emissions damaging the ozone layer in a way that will gradually, incrementally, accumulatively raise temperatures. Doesn't matter where they come from. It's not about proximity. The damage that China might do is a question of volume, but not a question of proximity. And so every megaton that China might be guilty of will have the same effect on British Columbia as every megaton that Saskatchewan might emit.
What's the constitutional significance of that?
The significance is that you're going to be, it's going to be suggested to you that the provinces are unable to deal with the question of climate change. It's just as meaningful to say that countries are unable to effectively deal with climate change. If it's the case that China refuses to sign on, some people might say, oh, this defeats the project. Well, that might be true, but it might still be important for British Columbia to do its part. It might still be important for Saskatchewan to do its part. But British Columbia is saying it is provincially unable to do what it wishes to do because of Saskatchewan's behavior. That is what they're arguing. I'm addressing that. This is their argument. And they're saying, therefore, you must see the pith and substance as being the necessity of a single Ottawa policy that is imposed on all of the provinces. Otherwise, the incremental effect that Saskatchewan has, which, by the way, is quantified in the materials, it ends up being, without the backstop, 1 megaton over 4 years, too many for Saskatchewan. And we're told that there's 40,000 megatons of emissions for the globe. So it's relatively infinitesimal. That's not the point. But the point is that this cannot be drawn by analogy to the Crown-Zellerbach facts. And we say Crown-Zellerbach is far easier to understand in a comparison to the interprovincial cooperatives case. Not sure if that helps, my lord. It's a theory of busybody federalism. We talked about coercive federalism, cooperative federalism. Now we're talking about busybody federalism, if I can put it crassly. This is British Columbia saying, well, we're doing this, and everyone else should too. That's not how our federation works. And it would be one thing if there was a genuine effect by Saskatchewan on a neighboring province. That's not what we're genuinely talking about. My time's almost gone, and so I'll try to accelerate my remarks. But I also want to mention here, my lord, that we took to heart your comments that on reply we should not be ensure that we don't get into matters that we could have dealt with before. So Mr. McAdam suggested that it may be more appropriate for that reason for us to dip into our other half hour in order to deal with some of the other interventions that we have from many of the interveners today.
Sure, that's your call. I mean, half hour is obviously a long reply, so if you want to dip in, I think you can dip in.
Okay, thank you. With the time remaining then, I want to turn to the question of pith and substance. And as is consistently pointed out by all participants, it's necessary to accurately identify the pith and substance of the measure in order to properly assess whether POG fits. And you heard Mr. McAdam's comments about the proper way to do that. And we think that the anti-inflation reference is the most helpful analysis of the way to do this. The ingenious solution of some of our opponents is to characterize the pith and substance as the establishment of a national standard of carbon pricing. I've already endeavored to demonstrate that that's a question-begging characterization. I referenced the Labor Conventions case earlier, and I'd like to use that as a useful example. The Privy Council examined whether labor standards fell into a provincial or a national power. They found in favor of a provincial power. Well, imagine if they said, Well, it might be that the provinces have been able to regulate labor standards and that it seems to fit within their list under Section 92 of the British North America Act, but we're not talking about mere labor standards anymore. We're talking about the need for a single national labor standard. One single province ought not to be allowed to defeat that purpose. Therefore, POG applies, and therefore POG displaces. After all, they might say, and remember, this is in the 30s, no one ever understood before the seriousness of the question. Labor standards have come to an unimagined importance in our day, with worldwide depression that we've never seen before, the rapid spread of Marxism. So important is this issue that Canada has entered into an international treaty. Very rightly, the Privy Council found that the desire for a single standard did not change the nature of the pith and substance of the measure. This is no different. You don't identify the pith and substance of a law as federal by insisting that it must be applicable to all provinces. None of the provincial powers are subject to a national standard. National standards involving provincial areas of competence are arrived at by agreement. National Building Code is an example of this. Again, this is why we look to and encourage cooperative federalism. In our factum, we make several suggestions, again, assuming this is not a tax, of how the federal government might characterize the act. One could look at several levels of generality and specificity to nail it down. Fighting climate change, regulation of emissions, reducing certain kinds of emissions, imposing pricing on certain emissions. This is approaching the kind of precision that allows for useful characterization, along with its effects, which Mr. McAdam emphasized. We review in the factum that the imposition of market interference has always been a provincial matter. And we refer to several cases in that respect. If we take the federal government at its word that the GGPPA is putting a price on carbon, then we know that every time retail markets are subjected to government interference, whether prices are artificially raised or lowered in order to change the economy, I'm not talking about interprovincial trade primarily, that is a provincial matter. The point is to further underline again that a new federal power over greenhouse gas pricing is a matter of displacement. Again, it becomes more and more clear why the federal government must resort to the radical POG power. We make no apologies for relying on strong cases from the Privy Council that have stood the test of time. They are not outdated, they are fundamental. In conclusion, my lords, my ladies, the Federation cannot survive the total erosion towards centralism if Ottawa may displace the provinces simply by entering into an international treaty and by emphasizing the importance of the policy. As indicated above, Ottawa and the provinces have every means available to arrive at a national approach. It's through cooperative federalism and the burden of persuasion founded on respect for each jurisdiction's sovereignty. And subject to any questions, my lords, my ladies, I'll turn it over to Mr. McAdam.
I didn't realize that there was another chapter in your argument, Mr. McAdam.
I'm simply raising to ask a question, my lord, a question about our reply argument. You will have noted that we haven't specifically addressed the arguments by any of the interveners this morning, and it was my intention to leave those arguments until our reply argument tomorrow. But I'm in your hands. I do not want to be accused tomorrow of splitting our case, so I am happy to deal with the interveners' arguments now, if that's your wish.
No, I think dealing with the arguments the interveners are going to present is perfectly legitimate territory for a reply, Mr. McAdam.
Okay. Thank you, my lord. Then we'll address that tomorrow.
All right, thank you. All right, we'll rise until 1:30, and at that time we'll hear from the Attorney General of Ontario.
Please rise.
Attorney General for Ontario. Mr. Hunt.
Thank you, my lord. Ontario is here today to stand shoulder with Saskatchewan and argue that the Greenhouse Gas Pollution Pricing Act is an unconstitutional intrusion into provincial jurisdiction. I will be focusing my submissions today on why the Act cannot be supported under the National Concern branch of the POG power. I'll rely on my written submissions for the other heads of federal powers, although, of course, happy to answer questions the court may have. And my colleague Padraic will then discuss why, even if the regulation of greenhouse gases did fall within federal jurisdiction, the charges this Act imposes infringe Section 53 of the Constitution Act 1867. For my submissions, I'd ask that you have before you volumes 2 and 3 of Ontario's Book of Authorities. I would like to take the court to the two seminal authorities, the Crown-Zellerbach and the inflation reference cases. So, on the National Concern branch, Ontario's position is the Act cannot be supported under the National Concern head of power, and it doesn't meet either branch of the test that the Supreme Court has articulated for establishing when a matter is a matter of national concern in the constitutional sense. I, of course, echo my friend's comments that just because a matter is of concern to the nation doesn't make it national concern in the constitutional sense. And on that note, just before I get into the actual scope of the power that's being claimed by Canada, I just want to draw a distinction that I think some of my friends for the intervenors have muddied a bit. And it's very important, as you all know, that when doing the pith and substance analysis, first you look at the Act itself and its purpose and effect, and then you classify it under a head of power, and that may involve, as it does here, interpreting the heads of power. It's the second step I'm focusing my arguments on. And that's why it's important to keep that step clear, because the first step, this is what the Act does. It's at the second step we're talking about, is greenhouse gas emission regulation a matter of national concern? And some of the interveners try and narrow the scope of the matter at issue, the matter that Canada is claiming, by saying, no, it's just about pricing, just about this one tool. And I say that's a false analysis. When you're talking about a matter, a head of power under our Constitution, it's the entire activity. Which tools Parliament or a legislature chooses to adopt in the course of regulating that matter is the first step. And so they've chosen one tool, a national uniform carbon price. But what they're asking for, and Canada's upfront about this in their submissions, is a federal head of power over greenhouse gas emissions and stop. Not just one aspect of it. And that has to make sense. I mean, that's how all the other national concern, it's not just putting a price on flight prices. It's aeronautics. It's not just regulating broadband prices. It's broadcasting. It's not just certain aspects of the national capital region, certain aspects of nuclear power. It's the entire matter. So I just want to make sure that we're clear about what it is we're talking about. Is the matter of greenhouse gas emissions properly transferred from the provinces, who have undoubted jurisdiction over it, to the federal government because it's a matter of national concern? And when we're talking about national concern, it's important to remember that the national concern branch, like all branches of POG, are different than Parliament's enumerated powers. Section 91 of the Constitution Act gives Parliament the power to make laws for the peace, order, and good government of Canada, and, notwithstanding anything else, the enumerated powers. The enumerated powers apply even if there's some overlap with the provincial powers. Give it a classic example: banking, bankruptcy. Those are clearly matters of property and civil rights, but they've been lifted out because they're in the enumerated list. The fact that they would otherwise fall within provincial power is irrelevant. It's in the list. That's all you need to do is look at the list in 91. For national concern, it's different. It's an exception to 92. It's taking those matters, because they've risen to this level of national concern, they've met the stringent test articulated by the Privy Council and the Supreme Court, that they can be transferred from provincial jurisdiction to federal. And why does that matter? It matters because the courts should exercise great caution when finding a matter has been so transferred. Because if taken to its extremes, there's great potential to upset the balance of our federation, which is based on the normal rule. There's a list in 91, there's a list in 92, and as my friends have talked about, each level of government is sovereign. It's co-equal within their respective heads of jurisdiction. And so the courts have recognized that in the national concern cases. Now, at that point, I'd ask the court to turn to the Crown-Zellerbach case, which is the leading case on national concern in the environmental aspect. That's at volume 2 of my book of authorities, tab 19. And in particular, page 432. I'm going to start with the majority decision of Justice Ledane, who found for the majority that marine pollution, I'll come back to that distinction that there was questions about from your lordship earlier, marine pollution was a matter of national concern. I'm then going to discuss what at this point was a minority decision by Justice Laforêt and became the decision of the whole court in Oceanport and then again in Hydro-Quebec, that pollution is not, and the concerns that were expressed there. And I'm going to submit that the greenhouse gas regulation is on the minority side. It's on the concerns that Justice Laforêt mentioned, not the specific reasons that marine pollution was found by Justice Ledane. And so the court at page 432, after doing a detailed history of the various older cases, sets out the test for the national concern branch. It sets out 4 tests. And it's 3 and 4, the black line sections, that are relevant to us today. So in item 3, the court sets out a 2-step test. And I submit it's important. They are 2 distinct tests, both of which must be met for a matter to be transferred from provincial jurisdiction to federal. 1, it must have a singleness, distinctiveness, and indivisibility that clearly distinguishes it from matters of provincial concern. I'll just note that clearly distinguishes. I would submit that's very similar to the qualitatively distinguishes in the general trade and commerce power that the Supreme Court's recently talked about in the 2 securities references. Same idea. It's not just, it's kind of the same thing. It's a clear distinguishment, and it has to be single, distinctive, and indivisible. The second step, and again, I say this is a second independent step, it must have a scale of impact on provincial jurisdiction that is reconcilable with the fundamental distribution of legislative power under the Constitution. In step 4, the court sets out an indicia of the first test, part of the test. It is relevant to consider what would be the effect on extra-provincial interests of a provincial failure to deal effectively with the control or regulation of the intra-provincial aspects of the matter. It's only an indicia. It is not a separate independent part of the test. It's certainly not a sufficient part of the test. Now, I'll come back in a minute to why I say it's not even met. But even if my friends can show provincial inability to deal with greenhouse gases, that is not enough to meet even the first step of the test, much less the test as a whole. Over the page at 434, Justice Ledane repeats this. The provincial inability test is one of the indicia for determining whether a matter has that character of singleness or indivisibility. But then he adds a caution. The provincial inability test must not, however, go so far as to provide a rationale for the general notion, hitherto rejected in the cases, that there must be a plenary jurisdiction in one order of government or the other to deal with any legislative problem. And really, if you boil it down, that's my friend's argument. This is so important a matter, only one level of government can do it. There's no room for cooperation. There's no room for differences of opinion. It's our way or the highway. You can't regulate. You can't sequester. You can't take other measures to fight carbon. It's put a carbon price that we think is good enough. That's the only way that works. That's not federalism. Just to finish off with the majority, let's just turn to the actual facts of the case, standing on page 436. The court emphasizes, this is at the section 5, marine pollution, because of its predominantly extra-provincial as well as international character and implications, is clearly a matter of concern to Canada as a whole. The Ocean Dumping Control Act, this is about 5 lines down, reflects a distinction between the pollution of salt water and the pollution of fresh water. And that's important. It goes on to talk about UN reports or marine pollution is scientifically different than freshwater pollution. And that's important, the court notes, because at the top of 438, the proposed power must have ascertainable and reasonable limits insofar as its impact on provincial jurisdiction is concerned. I'll note the court goes on, returns to this point in Oldman River at page 64, where it again notes that it is this whole idea that it's tied to the undisputed federal power over waters beyond the boundaries of a province, that's why it makes sense to say this isn't going to upset the balance. It's really an extension of existing federal power, and that's true of many of the matters recognized of national concern. It's not, as my friends talked about this morning, a wholesale regulation of all pollution into freshwater lakes and into the air that eventually makes its way to the sea, because that would be a huge intrusion on provincial jurisdiction. Regulating greenhouse gases is not analogous to this scientifically distinct and tied to federal heads of power matter that was found to be of national concern in Crown-Zellerbach. First of all, the Act doesn't talk about specific chemicals. The actual power in the Act is almost unlimited. The Part 1 applies to a fuel, which Section 3 defines as any substance, material, or thing designated by the Governor and Council. Part 2, Section 169, applies to greenhouse gases, which is defined as any gas, so at least more limited, it has to be a gas, designated by the Governor and Council and put in the schedules to the Act by regulation. Completely open-ended. And they discussed that, the minority in Hydro-Quebec discussed that you can't just look at the regs they've passed today. We're talking about the constitutional validity of the Act and of the discretion it confers on the Governor and Council. But even if...
Are we talking now about the nature of the subject matter that should be found to be under the national dimensions wing of POG, or are we talking about whether this particular piece of legislation can be slotted under that subject matter as characterized by Ottawa? Aren't you now kind of mixing things together?
So I would submit that in taking a look at the matter being sought, what Parliament's attempting to get jurisdiction for is a relevant consideration. This is an act that Canada says is supported by the power. I agree that at its outer limits, the power has to be limited to greenhouse gases, even if that is a matter of national concern, which I submit it's not. I would submit that if the federal government used the full force of this act to regulate everything, it would be ultra vires even this claimed power. But it does color that this is what they're claiming for. The point I'm going with is that even if it's possible to make a list, and to be fair to my friends, they have made a list of what it applies to today, of what greenhouse gases are, the scope of the matter still affects virtually everything. And that's because of the almost limitless range of human activities that generate greenhouse gases. It's everything we do. Driving in your car to hockey practice, heating your home in the cold of a Canadian winter, growing food for your family. All of it produces greenhouse gas emissions. And all of it, if my friends are correct, would now be subject to federal regulation. And those are exactly the concerns Justice Lafferay for the minority, which, as I say, later became the view of the whole court in Oceanport, when speaking about pollution. He says, this is at page 454 of the decision, and he goes on this for quite length. I'm just going to take you to one passage on 454 and 55. At the bottom, last paragraph, after going to the inflation reference, which I'll go to in a minute because I think it's also quite helpful, all physical activities have some environmental impact. Possible legislative responses to such activities cover a large number of the enumerated legislative powers, federal and provincial. To allocate the broad subject matter of environmental control to the federal government under its general power would effectively gut provincial legislative jurisdiction. Goes on page 455, about 7 lines down, just about the letter B. But environmental pollution alone is itself all pervasive. It's a byproduct of everything we do. And man's relation with his environment waste, and I would say if you substitute greenhouse gas emissions, would work the same, is unavoidable. And just to deal with the novelty point, I'll just note there, they said, even 1988, the problem's not new. Even though the scale has only recent years became clear that it's beyond the capacity of the atmosphere and the oceans to absorb. So this is not a novel matter. I don't say that that's determinative, but it is a factor to consider. And he concludes, to allocate environmental pollution, and I would submit greenhouse gas pollution is one aspect of that, exclusively to the federal parliament would, it seem to me, involve sacrificing the principles of federalism enshrined in the Constitution. A helpful analogy, I would submit, for what the scope of this new matter would look like can be found in Justice Betts' discussion in the anti-inflation reference. And that is at tab 22 of volume 3 of our Book of Authorities. Now, I should note that on this point, Justice Betts was speaking for the majority because Justice Ritchie agreed with him on the national concern point. He was only in dissent on the emergency point. I'll also say that what he was not in dissent was, and the entire court held on the emergency branch, was that emergency legislation had to be temporary. I'll just leave it at that. This act is not temporary. But getting back to national concern. He starts at page 458. Sorry, page 444. Come back to 458. At 444, he's talking about what would it look like if Parliament had a power to contain and reduce inflation. And as I'm reading all this, instead of contain and reduce inflation, think about contain and reduce greenhouse gases. I submit these statements apply equally well. Parliament could control all inventories, in the largest as in the smallest undertakings and trades. Those all make greenhouse gas emissions. Parliament could ration not only food, but practically everything else in order to prevent hoarding and unfair profits. Parliament could ration activities. How often do you drive your car? How big a house can you have? One could even go further and argue that such inflation and productivity are greatly interdependent. Parliament could regulate productivity, establish quotas, impose the output of goods or services which corporations, industries, factories, groups, areas, villages, farmers, workers should produce in any given period. Indeed, since practically any activity or lack of activity affects the gross national product or gross national carbon emissions, the value of the Canadian dollar and therefore inflation, it's difficult to see what would be beyond the reach of Parliament. Furthermore, all those powers would belong to Parliament permanently. Only a constitutional amendment could reduce them. And that point's important. Many of my friends on the intervenors' argument is, well, we like what the federal government's doing, so they should have power to do it. They may want to be careful what they wish for. Constitutional amendments are forever. And the next federal government could well say that they, in fact, want to override provincial carbon taxes, as, for example, the ones currently in place in BC and Quebec. And the court Justice Betts concludes at 458, the containment and reduction of inflation does not pass muster as a new subject matter. It's an aggregate of several subjects, some of which, in the case of greenhouse gas emissions, regulating local industries, local concerns, most of which, form a substantial part of provincial jurisdiction. It's totally lacking in specificity, and I note the activities that produce greenhouse gases are so lacking in specificity, even if we can make a list of chemicals. It is so pervasive that it knows no bound. Its recognition as a federal head of power would render provincial powers nugatory. So too would the power claimed by my friend. Unless the court has any questions, I'll turn it over to my colleagues to discuss Section 53.
Thank you, Mr. Hutter.
On Section 53, Ontario agrees with Saskatchewan that the Act fails to meet the legal criteria for a valid regulatory charge due to the lack of a proper nexus between the Act's regulatory purposes and the use of how the funds which it raises are designated under the Act. I want to start by emphasizing that the constitutional requirement under Section 53 imposes a distinct test from the classification exercise under Sections 91 and 92, which is an important point here where my friends for Canada have alternative arguments at both stages. So it applies in this way. If the court were to conclude that the Act is a valid federal regulatory statute under POG, then the test to be applied under Section 53 is the test for a regulatory charge, applying the test from the Supreme Court's decision in 620 Connaught. And this is my friend's primary position. Conversely, if in the Section 91 classification exercise, the court were to conclude that this is a valid exercise of the federal government's taxation power under 91.3, then there's a different test to be applied at the Section 53 stage, which is the test from the Ontario English Catholic Teachers Association case, which my friend was referring to earlier today. And there the question is whether the tax has been authorized in sufficient express form to satisfy the principle of no taxation without representation. So that's an alternative argument from my friends. I won't be addressing it in my oral submissions, but in Ontario's factum, we set out our view of why the OECTA test isn't met, even if the Act were to be supported under the federal taxation power. What I'll be briefly discussing is why this court should affirm the requirement that a regulatory charge, the funds raised by a regulatory charge, be used in a way connected to the regulatory purpose of the scheme at issue. And just to touch on the provisions, which there was a question about earlier, the sections of the Federal Act which make clear that there's no requirement to spend the funds on activities related to the regulatory purpose are Section 165 for Part 1 and Section 188 for Part 2. And what those provisions say is the only mandatory requirement is that the funds be distributed within the province they are raised from. They can be distributed to the provincial government in that province. They can be distributed to any persons prescribed by regulation. There is no requirement, and my friends don't dispute this, there's no requirement that the funds be distributed in any way that is connected to the goal of reducing greenhouse gases. So while it's true that this isn't general revenue in the completely unrestricted sense of many taxation statutes, what's missing here and what we say is required is a link between the use of the funds and the regulatory purpose. In the 620 Connaught case in 2008, the Supreme Court expressly declined to decide the issue of whether regulatory charge revenues can be used in such a way, where there's a behavioral purpose to a regulatory charge, as is claimed here by the federal government, whether those funds can be used for something unconnected. And that's at paragraph 48 of the Connaught decision, which is in Saskatchewan's Book of Authorities at tab 4. Ontario submits that in this reference, the court should decide that issue, and it should do so in favor of a rule which does not allow governments to easily circumvent the body of important constitutional law related to taxation by characterizing any former tax and now a purported regulatory charge as having a behavioral purpose. If only that low threshold was required to classify a charge as a valid regulatory charge under Section 53, even where the funds are used for general purposes, any number of such charges could be developed, dealing with any number of behaviors which the government wishes to deter. It would be open to the government to fund its entire operations from the revenue of such charges and permanently evade the requirement in Section 53 that a tax be called a tax. It is for this reason that Ontario relies on the Supreme Court's caution in an earlier regulatory charge case, the Allard decision, which is at tab 3 of Ontario's authorities. And there, the court, although an obiter, the court cautioned that if we interpret non-taxing provisions, regulatory provisions, in that case, provincial regulatory provision, but the caution there was fundamentally, if non-taxing provisions are interpreted so broadly that they allow essentially the raising of revenue for general purposes under the guise of a regulatory purpose, the effect will be to render the tax-concerned provisions of the Constitution Act meaningless. The restriction in Section 53, the restriction, the equally important restriction in Section 125 that governments are not able to tax each other. In the case of provincial powers, the limitation in Section 92 that they can only levy direct taxes and not indirect taxes. All three of those provisions would have very little meaning if it were open to governments, whether federal or provincial, to raise huge amounts of funds to be used for any purpose it wishes under the guise of a behaviorally targeted regulatory charge.
Mr. Ryan, what's the significance, if any, of the fact that in this case, all of the funds raised by virtue of these levies have to be returned? So they can't go into some kind of general pool in a typical sense and be used to build highways or whatever? Or do you read the act as being sufficiently broad or flexible that in fact the federal government could take the funds coming from these levies and build a highway or a harbor or whatever else the federal government might expend funds on?
The point is that even if how you spend the funds is designated within the same act, there's no requirement that it be spent in a way linked to the regulatory purpose. So if it were sufficient to meet the requirement under Section 53 by in any legislation saying that we will collect the charge and in the same act we designate how we spend the charge, that would be a very wide loophole in Section 53. And what you're describing is what's sometimes called in other contexts a revenue neutral statute. And I think it's important to address that point because this is a fiscal or a policy concept which is not relevant to the classification of a charge in legal terms. So revenue neutral simply means that a piece of legislation raises and spends the same amount of money, so it doesn't have a net impact on the provincial or federal treasury. That can be true of many kinds of charges which are just simple taxes. All that it means is that the legislation designates both sides of the fiscal book. It doesn't tell us what the purpose of the charge is and whether it's used in a way that satisfies the requirement under Section 53 for a link between the regulatory purpose and how the money is spent. And we have a quote from Professor Hogg on our factum where he expresses his view that a revenue neutral statute is simply a taxing statute because it's about raising revenue and spending it, which is what taxation is. I would note that although, of course, legally the question is the act on its face, we know that in this case, Canada has designated that some of the funds will be transferred directly to provincial treasuries, where they can be used for anything, including your example of building highways. That's in the jurisdictions that have voluntarily accepted the act. They can be refunded to individuals who can spend money in ways contrary to these regulatory purposes, excuse me. And we know that there are other funds where the government has yet to designate how those funds will be used, and they have the power under the act to distribute them for any purpose or to any prescribed group. There's no limitation that the funds be used consistent with the regulatory purpose, and that's what we say is the constitutional flaw under Section 53.
Thank you. We'll hear now from the Attorney General for New Brunswick, Mr. Gould.
My Lord, Honorable Chief Justice, my ladies, my lords. It might be interesting, if not essential, to continue the conversation today discussing cooperative federalism, regulatory schemes versus taxes originating in Parliament, a la Connaught, West Bank, and a host of others, causal costing. But you've heard it, and you will likely hear more. There's no need to discuss the gospel according to John Stuart Mill and the nature of taxes and whether Section 53 is met here or not. I will reiterate a couple of the comments of my colleagues from Saskatchewan. First, the submissions that I will make today are based on the assumption that this is not a tax and that some deference must be shown to the Attorney General of Canada regarding the way in which this matter has been characterized. So what I want to do is to drill down into something that did seem to trouble my Lord the Chief Justice this morning, and something that I'll call this enigmatic indivisibility that may well be at the heart of this matter. But before going there, I'd like to simply make a quick reference to the article Sir Lyman Duff in the Constitution, as also quoted in the anti-inflation reference case, which appears at the AGC tab 26 and Ontario's tab 22. And this is from page 261 of that article, and I quote, "Many matters within provincial jurisdiction can be transformed by being treated as part of a larger subject or concept for which no place can be found within that jurisdiction. This perspective has a close affinity to the notion that there must be a single plenary power to deal effectively and completely with any problem. The future of the general power, in the absence of an emergency, will depend very much on the approach that the courts adopt to this issue of characterization." And I would submit that that issue of characterization is essentially synonymous with, in this matter, that distinct, single, and indivisible element, and whether or not this can qualify properly as a national concern. Now, there have been many attempts to describe unitary legislative subjects that arguably transcend the distribution of legislative powers, seemingly in need of that single plenary power. There's been the environment, economy, language, even beer labeling, aviation, firearms, and as well, Crown-Zellerbach's marine pollution. Now, some of these seem vast with elusive and intangible boundaries, and some seem by their nature to have a greater unity, but that's an intellectual construct. That's before any legal, constitutional, esoteric refinement is made. Now, some matters, and not necessarily just on POG, but beyond that, again, the struggle to find that unitary legislative subject. Some matters can be rationalized as having a beginning, a middle, and an end, and emergencies, for example, they get slotted away accordingly. Some are less distinct, and they can fall into plenary hands where the trailing effect is merely incidental. Some undertakings are regarded as immune from countervailing authority. Generally, matters on the fringes of these constitutional heads of power require that the scrutineers find as much unity as possible prior to determining who can do what. So where do we go from that? What is the unitary legislative subject? What is the single indivisible thing? Well, let's leave the courtroom, and anyone could understand, for example, that a curling rock or a hockey puck has a certain unity of form. They both sit atop the ice. They are distinct from the ice. At no point do either one of them ever somehow morph down into the ice. And frankly, taking it up a notch into a more esoteric legal construct, most anyone could be brought to understand the necessary degree of extra-provincial unity that aviation requires. In the modern age of big old jet airliners, we have flight paths, we have flight languages, even local zoning for ground support infrastructure. Most anyone could get that over a campfire chat. But, inevitably, we must leave the campfire, and we must come here. Inevitably, we must address that stubborn jurisdictional concern that arises from the great compromise that we find in sections 91 and 92. So the unity, whether we're talking curling rocks or Crown Zellerbach's marine pollution, it is necessary to understand the elements in order to be able to distinguish a matter from its surroundings. The indivisibility, the unity, there must be a perceptible form. Now, look at Crown Zellerbach, which AG Ontario tab 19. The Ocean Dumping Control Act distinguished between the pollution of salt water and the pollution of fresh water. Speaking of water, both types of waters having different compositions and characteristics, much like a hockey puck atop the ice. And from this, an area of federal authority that did not intrude upon or alter the basic distribution of powers was found. In Hydro-Quebec, the CEPA, or the Canadian Environmental Protection Act, did not sufficiently distinguish between diffuse long-term pollutants that respect no boundaries and temporary pollutants that stay put. And that lack of refinement to the sought-for unity was fatal. If there had been sufficient unity, then perhaps something akin to Crown Zellerbach could have been fashioned, assuming for a moment that the resulting matter did not strike at the heart of provincial competence. So the selection of that indivisible mass, this thing I call the enigmatic indivisibility, this is a vital rite of passage for any federal law that relies upon the national concern doctrine under the general power. And it's vital because it will give Canada a plenary power, now and most likely forevermore, enabling a host of regulatory change and adjustment, potentially further eviscerating the local authority regardless of all else. That plenary jurisdiction is all changing. So without a determination regarding the single, distinct, and indivisible subject matter, there can be no national concern. So what do we have here? What we have here is, frankly, quite a bit of uncertainty even regarding the nature of the enigmatic indivisibility. The Attorney General for Canada says that GHG emissions are a single, distinct, and indivisible subject matter at page 30 of its factum. Now, the AGBC goes one further and says that in the spirit of Justice Ledain's writing on the subject, it must be read as narrowly to the point of being quote, the setting of minimum standards of stringency for pricing access to Canada's share of global greenhouse gas emissions, end quote. That's a stunningly erudite factum of the AGBC, and I look forward to it, but frankly, I would submit that that is more of an action item than it is a national concern. So, meanwhile, the AGMB wandered lately into the fray and described the unity that might give rise to national concerns as GHG megatonnage reduction, as articulated in the factum. And from there, optimistically, possibly a cooperative scheme could have been concocted that respected federalism. And the factum also points out that GHG emissions are simply not a suitable analog to Crown-Zellerbach's marine pollution. So in the room, we have a fair bit of uncertainty even regarding what the indivisibility is. How has Canada gone about it? How have they gone about the task of defining it? Canada is saying that GHG emissions are a matter of national concern because, as they factually set out, they say that, well, the United Nations framework on a Convention on Climate Change requires annual reports on GHG inventories, paragraphs 21, 22, and 23 of their brief, and that climate change and GHG mitigation policies were discussed leading to the Vancouver Declaration, certainly, and that was paragraph 24. A working group came out of the Vancouver Declaration, and its final report made carbon pricing the key premise, equating the largest GHG reductions with the, quote, higher carbon price scenario, paragraphs 26, 27. And this led to the announcement of the pan-Canadian approach to pricing carbon pollution and the same-day document that explained that any economy-wide carbon pricing is the most effective way to reduce emissions within a larger national framework that purportedly permitted flexibility at the local level. And also that a pan-Canadian framework on clean growth and climate change emerged with a multifaceted approach, quote, recommended by international organizations, end quote, to effect a transition to a low-carbon economy, paragraphs 31, 32, and 33. Those are the facts supporting the argument. Now, regarding the argument going to this requisite indivisibility necessary to make GHG emissions a national concern for the purposes of the general power, Canada goes on at paragraphs 84 and 85 to cite a number of cases which speak to the unquestionable need for humanity to preserve its natural environment. And then Canada says, paragraphs 86 and 87, that GHG emissions cannot be contained within geographic boundaries. The UNFCCC concerns are reiterated. Canada says that the molecular properties of GHG emissions are known. Certainly they are. And that the impacts are known and they're not site-specific. No issue. And the impacts are many, none of which are good. No issue. And the impacts affect Canada as a whole. No issue. And that GHG emissions are a new matter. Well, we might take some exception to that, but others have spoken and will speak to it. Next, Canada zeroes in on the requisite indivisibility as follows. Canada emphatically states that GHG emissions are distinct, at paragraph 88, and that GHG emissions are distinct because UNFCCC says as much, and that they are a precisely defined type of environmental pollutant, being, quote, those gaseous constituents of the atmosphere, both natural and anthropogenic, that absorb and re-emit radiation. And quite importantly, much reference is made of Schedule 3 to the Act, which lists 33 GHGs, and that it is noted that these are unlike the broad, quote, toxic substance, end quote, definition in Hydro-Quebec that exceeded solely interprovincially polluting toxins at paragraph 91. So that, you know, because of the precision of Schedule 3, there is a difference, Canada would say. So much apparently depends upon Schedule 3 because of its precision with its 33 molecular formularies and the numerical representation of its global warming potential. Because of these things, it is indivisible. GHG emissions are a single, distinct, and indivisible matter because of the international accords and the Act, and that they're crystal clear regarding what they are, and there is certainty regarding what they do. So that is, Canada has offered a monolithic creation requiring management. Now, it does certainly, admittedly, sound like something single, distinct, and indivisible. It is something rather single, distinct, and indivisible. But so is a hockey puck, and so is a curling stone, and they are certainly not national concerns. And this is, we would submit, this is the problem with the approach. The mere offering up of that monolith, it shows no respect for the indivisibility that is suggested by the law. So we ask, how has the ambit of the Act been circumscribed to demonstrate that the matter is unified distinctively from otherwise prevailing heads of provincial power? Is it enough to hold up the creation as it has been done here, birthed from a sense of global gravitas, contained in a list of 33 molecular compounds, to justify this most certain intrusion into provincial authority? Now, Canada relies on the Hydro-Quebec case quite a bit in its support of these insertions, so let's deconstruct it. Let's deconstruct it from that vantage point. Canada says, again, that the ambit of the Act is GHG emissions. Again, I'm treating that synonymously with the singleness, the distinctiveness, the indivisibility. And we have law, including Hydro-Quebec, which says that once the national concern is determined, that Canada essentially has a hall pass into this plenary jurisdiction. So is it enough to create this thing on its own? Well, let's say for a moment that GHG emissions meet the standard of analysis in Hydro-Quebec. Let's say that they are, in fact, a precisely defined type of environmental pollutant with specific characteristics, which they are. Let's say they're solidly backed by the UNFCCC as having a singularity going to their ability to absorb and reabsorb, readmit infrared radiation. And let's say that they are unquestionably migratory, that they leap out of a smokestack or a tailpipe and head straight for the first political boundary they can find, intent on heading up into the upper atmosphere so they can absorb and readmit infrared radiation. Well, this is it. And we would agree with that they are these things. But is that it? Does Canada get plenary jurisdiction such that it can impose carbon pricing from that? And we would submit no. Are there any qualifications before the plenary power is conferred? Or once the monolith is created, is that it? Are we looking at a fully qualified constitutional national concern? No, we are not. Let's look at, well, no, we don't need to go there, but paragraph 8 of Hydro-Quebec, the Supreme Court's looking back at the Superior Court. And it's noted with respect to the Superior Court justice. He held that the provinces would have to be unable to deal with the matter themselves, quote unquote. And that's important because that sentiment has reach through all levels of that case and various other cases. What does it mean? Well, let's start with the idea that the Supreme Court of Canada is not likely to recognize a new implied head of federal authority if its operation would have an undue impact on a provincial authority. Let's start with that proposition. Is there any authority for that proposition? Yes, there is. And suddenly we are into the heart of the matter. And it's something that my friends from Ontario referred to, and I'd like to drill down a little bit more into it. Paragraph 33 of Crown-Zellerbach has 4 quote-unquote firmly established conditions. And the one I want to settle upon is number 3. And again, and I quote, "For a matter to qualify as a matter of national concern in either sense, it must have a singleness, distinctiveness, and indivisibility that clearly distinguishes it from matters of provincial concern, and a scale of impact on provincial jurisdiction that is reconcilable with the fundamental distribution of legislative power under the Constitution." That is echoed again in Hydro-Quebec at paragraph 66. We, quote, "We must then determine whether the matter has the required singleness, distinctiveness, and indivisibility that clearly distinguishes it from matters of provincial concern, and whether its impact on provincial jurisdiction is reconcilable with the fundamental distribution of legislative power under the Constitution." 2 criteria there. But most tellingly, that final sentence in paragraph 66. Only if these criteria are satisfied will the matter be one of national concern. Said another way, we're talking about those ascertainable and reasonable limits that are also referenced in Crown-Zellerbach as drawn from the anti-inflation reference, noted at paragraph 39 in Crown-Zellerbach. But there are a couple of criteria there that are essential. They must be satisfied. That is the law here today. They must be satisfied. Only then will the matter be one of national concern. That requisite singleness, distinctiveness, and indivisibility. They are being treated as conditions precedent to even finding the matter one of national concern. So here we have, Canada has created this monolith, but they've either ignored or paid insufficient respect, I would submit, to those criteria. And another thing that's worth noting is that the cases that are being discussed, they're all about offenses, prohibitions on marine dumping, prohibitions on environmental toxins. The matter here concerns a regulatory main thrust of behavior modification. It's not an insignificant point. Prima facie, when you're into an aspect like that, I would submit that we are into property and civics and local matters without any doubt. It's simply utterly impossible to distinguish the regulatory reach from the matters of provincial concern. And I would submit that the scale of impact is completely irreconcilable with the fundamental distribution of legislative power. Giving Canada this degree of regulatory authority over GHG emissions will result in a limitless, intrusive federal regulatory capability over provincial affairs. It only begins here. And that was a long and drawn-out way, perhaps, of saying that the Act must be sufficiently distinct from provincial heads of power. And in closing, the Attorney General for New Brunswick would urge this honorable court to pay close attention to paragraphs 33 and paragraphs 60 of Crown-Zellerbach and 66 of Hydro-Quebec, and think through those two criteria, those two conditions precedent to even finding a matter of national concern. And to draw again on one sentence from Justice Ledane in the article that I commenced with, the future of the general power in the absence of an emergency will depend very much on the approach that the courts adopt to this issue of characterization. We are at a crossroads. Those are my submissions.
Thank you, Mr. Gould. Next, we have Sask Power and Sask Energy, Mr. Thera.
Good afternoon, my lords and my ladies. I'm David Thera, and I'm here with Robert Affleck on behalf of the intervenors, Saskatchewan Power Corporation and Sask Energy. Our submission is that the Greenhouse Gases Act intrudes on provincial jurisdiction by way of Section 92A of the Constitution Act, and that it also imposes a tax on provincial crowns, thereby contravening Section 125 of the Constitution Act. I'm going to focus my submissions on Section 92A because I think that's the aspect that more appropriately reflects our client's unique perspective on this matter. Of course, Section 92A is the product of a relatively recent amendment to the Constitution and represents the culmination of a bargaining process between the federal and provincial governments. Section 92A grants exclusive jurisdiction to the provinces on matters relating to, firstly, development, conservation, and management of non-renewable natural resources, and secondly, development, conservation, and management of sites and facilities for the generation and production of electrical energy. In our submission, the Greenhouse Gases Act directly intrudes on that area and is designed and intended to intrude on that area. Just by way of background, of course, Saskatchewan Power Corporation is a Crown corporation and an agent of the Crown. Sask Power's mandate by legislation includes generating, distributing, and supplying electrical power to the province. Its mandate also includes by legislation promoting, participating, and carrying out of programs to encourage energy conservation. We've filed material indicating Sask Power's commitment and plan to reduce greenhouse gas emissions. Sask Power has a goal to achieve by the year 2030 a reduction in carbon dioxide emissions to 40% below 2005 levels and up to 50% renewable electrical generation capacity. The plan includes reducing Saskatchewan's and Sask Power's current and historical reliance on coal for power generation and replace it with natural gas, which of course is a non-renewable resource, but also with renewable, with power from renewable sources, including wind and solar. Sask Energy, of course, is also a Crown corporation and also an agent of the Crown. Its mandate includes production and distribution of natural gas in the province, and Sask Energy also undertakes its own initiatives to promote efficient use and conservation of natural gas in the province. Both Sask Power and Sask Energy will be financially impacted by the Greenhouse Gases Act. The act is designed to and intended to achieve its goals by imposing that financial impact. We've set out some projections and estimates in the material that we filed on the magnitude of that impact. Of course, the potential magnitude is, the exact amounts are open to debate, and I understand that some of the intervenors who will follow may enter into that debate. The point, though, is that the exact amount, or the exact projected amount of the burden is not relevant, except in the sense that it is going to be a significant burden. It is intended to be a significant burden. It has to be a significant burden in order for the act to achieve its purpose of influencing behavior. The intent of that financial burden, the intent of that financial impact, is to regulate and interfere in our submission with Sask Power and Sask Energy's management on behalf of the province of its non-renewable resources and an interference in the manner in which Sask Power generates electrical power in the province. Again, Section 92A grants exclusive jurisdiction to the province to regulate and manage those resources, and by consequence, I would say, to manage those resources and to manage electrical generation in a manner that reduces emissions and at the same time continues to meet the needs and the unique needs of the province of Saskatchewan, of the population of Saskatchewan. Again, we submit that the Greenhouse Gases Act intrudes into Saskatchewan's jurisdiction under Section 92A and intrudes on Saskatchewan's own initiatives to reduce emissions. We've argued in our factum that the Greenhouse Gases Act interferes with provincial jurisdiction in a manner that is likely to be counterproductive to Saskatchewan's own efforts and in the long term counterproductive to the goal of the Act. And the way that comes about is that the financial burden imposed on the Crowns will interfere, is likely to interfere with the Crown's ability to invest in research and development of renewable energy sources. And of course, one of the chief reasons for that is that hydropower or power from hydro is not readily available, or is of very limited availability in Saskatchewan due to our geographical location. Because alternatives like hydro are not available, the Act forces Saskatchewan into a situation where it has to commit to natural gas as an energy source in at least the medium and short term, and in doing so again takes away from Saskatchewan's plan to and ability to devote resources to energy from renewable sources. Of course, all interference in provincial jurisdiction is unconstitutional and unacceptable, whether the aim or whether the result is benevolent or productive or counterproductive. The issue here is not who has a better plan to reduce, or a more effective plan to reduce emissions. The issue is that Section 92A grants to the provinces exclusive jurisdiction to manage their non-renewable resources and to manage the generation of electrical power in the province. The GGPPA in our submission wrongfully intrudes on Saskatchewan's constitutional jurisdiction. It is designed to do that. It is intended to do that. And if it proceeds, it will do that. The province of Saskatchewan, through its crowns, through Sask Power and Sask Energy, has a commitment and has a plan and has exclusive jurisdiction to manage its non-renewable resources and to manage its electrical generation system in a manner that reduces emissions, but in a manner that also recognizes the unique historical and geographical and geological situation of our province. We also argue that the federal government's intrusion into Saskatchewan's jurisdiction cannot be justified under the peace, order, and good government provisions contained in Section 91 of the Constitution. I won't repeat all of the arguments that have been ably made by those who spoke earlier today, but would point to the opening phrase of Section 1, the opening segment of the peace, order, and good government power, which of course, specifically says that the power can only be invoked on matters that are not exclusively assigned to the provinces. So the peace, order, and good government power can be invoked to ooze into cracks and gaps, but cannot be used to override a matter of exclusive provincial jurisdiction. We also submit that the Act does not meet the national concern test. I think that's been fully covered by others who have spoken, so I won't repeat what they've said. Just a word, though, if I might, on the provincial inability part of the peace, order, and good government test, or the test for invoking that power. Provinces have the ability to regulate emissions from particular sources that exist in the province, chiefly in my client's case, power generation. Provinces have the ability to make their own decisions on investing on making decisions into methods of power generation that reduce emissions. And again, the provinces have not only the ability, but the unique situation or ability to do that in a manner that recognizes the historical and geographical situation in a province. The taxation argument, again, I think the issue of whether the Act is a tax or a regulatory charge has been covered already, and I won't repeat those arguments, except to say that my client's position, or the position of my two clients, is that if it is a tax, it's unconstitutional under Section 125, or offends Section 125 of the Constitution. So I think you've heard already, the case is not about, and is not from our client's perspective, about the urgency of the problem of climate change. The case is not about whether a carbon tax is the best or the most efficient way of reducing emissions. From our client's perspective, the case is about battling greenhouse gas emissions in a manner that, firstly, respects the division of powers set out in the Constitution, and secondly, respects provincial autonomy in areas that have been specifically allocated to the provinces in the Constitution. So with that, I will close and thank the court for giving my clients the opportunity to intervene on this very important matter.
Thank you very much, Mr. Thera and Mr. Affleck. Our next intervener is the Canadian Taxpayers Federation, Mr. Hallsor or Mr. Shalashniy.
May it please your lordships, your ladyships, my name is Hallsor, and Mr. Shalashniy is with me. I thank you also for the opportunity for the Canadian Taxpayers Federation to make submissions in this important case. As I'm going to, we cover three areas in our factum. I'm really going to focus on one area, and that is the issue of whether the tax is a regulatory charge or a tax. I'll briefly discuss the other two issues. The first issue we raise is an issue of the efficaciousness of the carbon tax, and I think my friends who've gone before me have covered it well. That's really not the issue before this court. It was raised, my client wished to have this matter, some evidence raised, because there's evidence from the Attorney General of Canada and some of the other intervenors that the carbon tax is the greatest thing possible, and it's the only way to solve the climate change crisis. I wanted to have some evidence before this court that there is some dispute and there's some debate over that issue. It's certainly not going to be the role of this court to determine that debate, nor should it. If that is the reason that the federal government is giving for implementing this, that's up to them, and it's not for the court to review. But, you know, whether or not pricing carbon to the consumer in a highly inelastic market will affect the amount of kilometers a family has to drive in a year, or where they put their thermostat on a day like it is outside today, whether that will have any effect, you know, short-term or long-term on the greenhouse gas emissions, I would respectfully submit as a matter of debate. And that's all I really intend to say about it, and that's all our evidence is there for. I think what is important, and I'm not dealing with the issues that my friends have raised on the issue of federalism generally. The Canadian Taxpayers Federation adopts and urges this court to adopt the arguments that you've heard this morning from the Attorneys General of Saskatchewan and Ontario and New Brunswick on that point. But frankly, from the unique perspective of my client as an intervener, ordinary taxpayers aren't particularly fussed when they're at the gas pump over which level of government is imposing a carbon tax or has the jurisdiction to impose a carbon tax. What is of concern is that is the creeping issue, which is that things may or may not be taxes and things may be regulatory charges. Regulatory charges can be legislated without the same degree of supervision as tax and without the same amount of accountability. And that's really why the Canadian Taxpayers Federation wishes to focus on that particular issue. As a general rule, which government imposes the tax is not as important from our perspective as that the court recognizes taxes are taxes. As you heard this morning, if it walks like a duck and it quacks like a duck and it looks like a duck, it's a duck. And if it behaves like a tax and it affects people like a tax, then it's a tax. And people should have the right to expect that Parliament or the legislature will impose taxes and not unelected bodies. So having introduced that, I'm going to skip the first 6 pages of my factum and just skip ahead to page 7, although I don't intend to follow it verbatim. But on page 7, I describe the 3 points. The first one is the carbon tax does not necessarily reduce emissions to the degree that the Attorney General of Canada suggests. Carbon pricing is a theory. It's a theory that if this pricing goes into effect, that people will consume less greenhouse emitting gases. That theory has not been tried extensively yet. The jury is still out. The second point is that the carbon tax is a tax rather than a regulatory charge. And the third point I'm going to discuss is that the federal carbon tax does not adhere to the constitutional principle of no taxation without representation, which is a long-standing principle enshrined in our Constitution going back to the English Bill of Rights. So I'll turn to page 9 of my brief at paragraph 30 on the issue of a tax. So the test for whether a levy is a tax or a regulatory charge is well established. First, this court must consider whether Sir Lyman Duff's indicia of taxation are met. Sir Lyman Duff, in the Lawson case quoted by Mr. Justice Major in Irig, found that there are 4 indicia by which you can recognize a tax. First of all, the tax is enforceable by law. Well, Secondly, is it imposed under the authority of the elected legislature? 3, is it levied by a public body? And 4, is it intended for a public purpose or use? Clearly, on the first test, the carbon tax is enforceable by law. On the second test, the Attorney General of Canada states in her factum that it is authorized by Parliament. Thirdly, the carbon tax is certainly imposed by a public body. And of course, on the fourth ground, the Attorney General also states that the carbon tax is intended for a public purpose. So having certainly passed that 4-part test, the next test is the one from West Bank, which is a 2-stage test. West Bank Indian Reserve, that's the case where West Bank Indian Reserve wished to impose essentially a property tax on a provincial crown agency, BC Hydro. In that case, the initial stage considers whether a regulatory scheme exists, and the secondary stage is whether the levy is suitably connected to the regulatory scheme. The CTF's position is that the carbon tax doesn't satisfy either part of that stage and is therefore a tax. Quoting from West Bank, a court should look for the presence of some or all of the following indicia of a regulatory scheme. Firstly, a complete, complex, and detailed code of regulation. Secondly, a regulatory purpose which seeks to affect some behavior. 3, the presence of actual or properly estimated costs of the regulation. And 4th, a relationship between the person being regulated and the regulation, where the person being regulated either benefits from or causes the need for the regulation. So beginning with the first stage, this Carbon Tax Act is not a complete and detailed code of regulation, nor is it part of a complete and detailed code of regulation. The Canadian Taxpayers Federation respectfully submits that it is that the legislation established is similar to the tax under the reference in natural gas export tax. And there the Supreme Court of Canada considered a levy on Alberta's natural gas. In its finding that the levy was a tax, the majority of the Supreme Court made the following comments. As will be seen here, there is nothing in Part 4.1 added to the Excise Tax Act which in any way regulates the flow of natural gas produced in Canada through interprovincial or international channels. It is not a conservation statute, nor is it indeed a price regulating statute. It has nothing to do with the channels of industry into which the gas should be routed. For example, in replacement of electricity, coal, or other sources of energy. In short, it is purely, as announced in the budget and the National Energy Program of 1980, a revenue-raising measure. Well, that's exactly what this is, certainly Part 1 of this legislation. This doesn't regulate the use of greenhouse gas-emitting fuels. It doesn't restrict them. It doesn't purport to affect the prices of them. It simply charges a tax on them, no different than the GST or other taxes that are charged on fuels today.
How does imposing a tax not affect the price?
Well, certainly the Supreme Court of Canada found that imposing a tax on natural gas export tax doesn't regulate the price in the sense that the government is not establishing a minimum price or a maximum price. The market will continue to do that, and it will continue to do that for gasoline and home heating oil and other things. It's simply a tax on the price. The stated aim of the Dominion is not to lower the price or raise the price. The stated aim is to reduce consumption. Arguably, that's exactly what the GST does as well, no different. It looks like a tax, it acts like a tax. It doesn't look or act like an attempt to regulate, restrict, control the use. It's a theory that the result of a tax being imposed will reduce consumption, a theory we're used to with cigarette taxes, alcohol taxes. but whether that theory will bear fruit is a very indirect relationship. It is not a direct regulation or a direct control of prices. What is direct is that people will pay a levy or a charge which looks and acts like a tax. The entire Act contains nothing but rules and protocols for applying the carbon tax. The two parts of this Act are not just two parts of a 10-part comprehensive environmental or green plan or legislative scheme. Contrary to the Attorney General of Canada's suggestion, there is nothing in this Act that makes the carbon tax part of a legislative scheme aimed at the development of more affordable green technologies, for example. Just as in the reference re natural gas export tax, there is no broader regulatory scheme in place beyond legislation aimed at collecting revenue. The 620 Connaught case that you've heard about involved a levy related to Jasper National Park. That levy was related to a statutory scheme that envisioned and tended to fund the maintenance and administration of Jasper National Park. In that instance, it was found to be a regulatory charge. The park is charging money, it's being spent in the park, it's all about the park, people can choose to come into the park and use the park or not. In this instance, the carbon tax is more analogous to putting a toll gate on the Yellowhead Highway. That might support the highway, or a toll gate on the highway that doesn't have any particular effect on users of the highway. It's simply a highway toll. It becomes a tax. As such, this legislative scheme is closer to the natural gas export tax, and on that basis, the first stage of the West Bank test shows that it's a tax and not a charge. As to the second stage of the West Bank factor, I'm not going to go over that. While the carbon tax may have a goal of reducing greenhouse gases, and it may even be effective at doing that, as I said, that's a side effect. There's no direct there. What is direct is that people are paying a levy every time they fill up their car. As to the third stage of the West Bank test, here too the ineffectiveness of the carbon tax shows a disconnect between the tax and a broader regulatory purpose. As Ontario points out, in its factum, there is no direct link to using the revenue here for any purpose related to the reduction of greenhouse gases. There may be a suggestion that the revenue, it will be revenue neutral to the federal government because the federal government is going to return the money to taxpayers. But that return has nothing to do with how much taxpayers consume. I might put a solar panel on my roof, I might buy an electric car, I might do all kinds of things. That makes no difference to whether I get any kind of money back from this tax. I might be the biggest polluter on my block, leave my lights on all the time, heat my house too much. I'll still get the same rebate as somebody else down the street. As I understand, will be provided on income. Giving people rebates based on an assumption, based on their income, as an income tax credit, isn't in any way directly connected to the use of carbon and can't be considered part of a regulatory scheme. At the most, it's a political sales job to make the sale of the tax more appealing. The fourth factor in the West Bank test considers the relationship between the ostensible regulatory scheme and the set of persons that are being made subject to the federal carbon tax. For instance, in the 620 Connaught case, the regulatory scheme pertained to the maintenance and administration of Jasper National Park. And the persons who were subject to the levy were the patrons of that park. So there was an obvious connection and relationship. Here, there is no direct and obvious relationship between a Saskatchewan family required to pay the tax and people who might benefit from a rebate scheme. The triggering condition for determining if a Saskatchewan family will pay the tax has nothing to do with their behavior. It has everything to do with whether the Privy Council of Canada decides in its wisdom whether or not the government of Saskatchewan has enacted a regulatory scheme that it likes. Government of Canada could change its mind every year. The government of Canada could say some provinces are in and other provinces are out and change that on a regular basis. That is completely removed from the behavior of the individual consumer. And so if the government of Saskatchewan doesn't satisfy the federal cabinet, then that same Saskatchewan family could drive all year and heat their house and pay this big tax. And if the federal cabinet decides that all of a sudden the government of Saskatchewan, even if it didn't change its policies, was now in compliance, then they won't pay the tax. The triggering condition has nothing to do with the individual who pays the tax. The triggering condition is solely dependent on whether the government of Saskatchewan's climate change policy meets the favor of the government of Canada of the day. So, although a charge may be issued in relation to the conferral of a benefit, here, this tax is all highway toll and no park toll. Saskatchewan families will not benefit from paying this tax, and some will have their energy costs increase and their cost of living increased with no direct relation to any improvement in greenhouse gas emissions in Saskatchewan.
Meter has expired. Mr. Hallsor, do you have a final point?
I guess I would just like to briefly say that the Section 53 of the Constitution Act, you've already heard, enshrines essentially the English Bill of Rights, no taxation without representation. This act would certainly be more acceptable if Parliament controlled it and set the levels and said who was in and out. This act, as you've heard already, is really administered to much too large a degree by non-elected body, cabinet, and if it is a tax, it should be unconstitutional for that reason.
Thank you, sir. I suppose we could power through and finish, but I did promise an afternoon break, and I can imagine that the benches at the back are rather hard, so let's take a 15-minute break, and we'll come back and hear from the final three interveners.
Please rise.
United Conservative Association, Mr. Martin and Mr. Dollansky.
Good afternoon, my lords and my ladies. Thank you. My name is Ryan Martin. I'm here with my colleague, Mr. Dollansky, on behalf of the United Conservative Association. I'd just like to start by thanking you for the opportunity to intervene in what our client obviously considers to be a very important matter, to provide an Alberta perspective on these important issues related to federalism. Albertans, I think, are known for having a history of resistance to the federal government's extension of its powers into matters of provincial jurisdiction, and that's something that would have been missing from these proceedings had we not been given leave, so we thank you for that. The United Conservative Association shares the concerns raised by the Government of Saskatchewan, the Government of Ontario, and the Government of New Brunswick that the manner in which the Attorney General of Canada seeks to justify the enactment of the Greenhouse Gas Pollution Pricing Act, which I'll try to refer to as the Act throughout today, represents an attempt to claim a new exclusive plenary jurisdiction over the regulation of greenhouse gas emissions in Canada, and that it does so in a manner that intrudes on the existing powers assigned to the provinces under sections 92 and 92A of the Constitution Act 1867. And it's the position of the United Conservative Association that allowing Canada to expand its constitutional powers at the expense of the provinces will upset the balance of federalism in Canada and will prevent provinces like Alberta, Saskatchewan, New Brunswick, Ontario from developing and implementing their own policy solutions to the problem of greenhouse gas emissions that are unique to the individual and local concerns of those provinces. It's my intention today to focus my submissions along the lines of the submissions in our factum. In particular, given some of the questions this morning, I'm hoping to address the test set out in Crown Zellerbach for the application of the National Concern Branch of POG. That I think necessarily requires us to address the question of how federalism operates in Canada, and we'd like to provide some perspective on the concept of subsidiarity and expand on what was provided in our factum on that issue. There was some discussion this morning about, and again this afternoon, about the question of whether this is a tax or a regulation. I think it would be fair to say that the Government of Canada has gone out of its way to stress in its media relations and its parliamentary addresses that this is not a tax. It's a price on pollution. So I would suggest that the options the court has are to take the Government of Canada at its word that it's not a tax, or we're left with the conclusion that the descriptions and the manner in which this legislation has been presented to the public has been, I would suggest at best, disingenuous. In the context of the application of the test for whether a matter meets or is a national concern under POG, I think it's important to heed the warning of the Supreme Court of Canada in the Hydro-Quebec case. In that case, the court, and it's at paragraphs 115 and 116, warns against the enthusiastic adoption of the national concerns doctrine. And it does so in the context of discussing how the subject of environmental protection is an all-pervasive matter, and that if accepted as falling within the general legislative domain of Parliament under the national concern doctrine, it would radically alter the division of legislative power in Canada. And it's our submission that that's exactly what is happening here, or what the Government of Canada proposes to have happen here, a radical alteration of federalism by shifting the exclusive jurisdiction to regulate greenhouse gases in Canada to the federal government. So the test for national concern, my friends today have already amply identified it for you. It's at page 432 of the Crown Zellerbach case. There's 4 points that are there. The submissions you've heard today, and I would repeat the submission, that the key point is point 3. And that point requires a singleness, a distinctiveness, and indivisibility that clearly distinguishes the matter from matters of provincial concern. And the and is key, because I think a lot of the intervenors and the Government of Canada overlook or downplay the requirement that there has to be a scale of impact on provincial jurisdiction that is reconcilable with the fundamental distribution of legislative powers. And there was discussion this morning about, is federalism an interpretive tool, or is it a principle that can actually lead to a finding that a piece of legislation is unconstitutional? And what the United Conservative Association would submit is that in the context of an attempt by the federal government to justify legislation under POG, federalism is not just an interpretive tool. And point 3 in the Crown-Zellerbach decision very clearly makes federalism a fundamental part of the test. That is to say that unless you can establish that the legislation has a scale of impact on provincial jurisdiction that's reconcilable with the distribution of federal powers, you can't say that something is a matter of national concern. And so that takes federalism from being an interpretive tool generally that you use to guide the interpretation of the Constitution into a fundamental aspect of the test that the court has to consider, and the court has to be satisfied that the government of Canada's efforts to justify the legislation under POG doesn't violate the principles of federalism. And if the court is satisfied that it does, or that it irreparably or improperly upsets the balance of federalism in Canada, then the court can't conclude that the issue is a matter of national concern. And that's exactly why, at the start of my submissions, I mentioned that in Hydro-Quebec, the Supreme Court of Canada warns against an enthusiastic adoption of the national concern power. Well, that's exactly why, because allowing or adopting the national concern branch as a solution to problems in Canada without proper consideration of the principles of federalism will ultimately or would eventually lead to the elimination of the provinces as effective legislative bodies. Now, going to the actual test, I'll try not to, obviously I'm largely, and the UCA is largely in agreement with the submissions made by my friend on behalf of the Government of Ontario, and as well the submissions that my friend on behalf of the Government of New Brunswick made, but I wanted to provide the Alberta perspective on this singleness and distinctiveness and indivisibility. In its submissions, the Government of Canada, or the Attorney General of Canada, tries to establish singleness by focusing on what they describe as a limited number of fuels that actually are caught by the legislation or that actually generate greenhouse gas emissions. And we would submit that that's not the whole story, and that's not the entire analysis that needs to take place here. What the court needs to consider is the reality of the situation, and that's that nearly every activity of Canadian life generates greenhouse gases to some extent, and nearly every sector of the Canadian economy generates at least some degree of greenhouse gas emissions. And so when we're considering whether or not the regulation of greenhouse gas emissions relates to a matter that is single or distinct or indivisible, I think you need to take that into account. You need to take into account the fact that everything that Canadians do is caught by this legislation in some way or affected by this legislation in some way. And every industry that attempts to develop or build in Canada or generate growth or wealth for Canada is affected by this legislation. So to say that we're only talking about 22 fuels or 11 fuels or 15 fuels without considering how those fuels are used and in what capacity and in what circumstances those fuels are used on behalf of Canadians is to overlook the breadth and scope of the matter of greenhouse gas emissions. And we would submit that for that reason, the regulation of greenhouse gas emissions in Canada does not have sufficient singleness, distinctiveness, or indivisibility such that it could qualify as a matter of national concern. And I just wanted to address, because it shows up in a couple of factums on behalf of, for lack of a better phrase, the other side. But the issue of the provincial inability test, and several of the factums that have been filed suggest that the provincial inability test is the test to determine whether or not a matter has sufficient singleness, distinctiveness, and indivisibility, and I would submit that that's not correct. My friends have taken you to the relevant section, but what the court says in Crown-Zellerbach is that provincial inability is an indicia of singleness, distinctiveness, and indivisibility, but it's not determinative of that question. And so it's appropriate in our submission for the court to consider more than just provincial inability and to go on to consider what is the scope and what is the breadth of this act, and is this really a unique set of circumstances that can be clearly distinguished from provincial matters, or is this something that is so broad and so ever or omnipresent in society that it can't? And again, our submission is that it can't, and relying solely on the provincial inability test, as some of the parties have urged the court to do, doesn't solve that problem. Even if you want to consider the provincial inability test, I think you have to consider it in the context of point 3 of the Crown-Zellerbach test, which includes both the concept of the matter being single, unique, and indivisible, but also it being on a scale that's reconcilable with the fundamental division of powers in Canada. And in our submission, regardless of anything else that you consider or decide, that's the issue that determines this case, because the effect of allowing the federal government to have the exclusive plenary jurisdiction to regulate greenhouse gas emissions in Canada is so inconsistent with the concept and the ideas of federalism, subsidiarity, and the balance of powers in Canada that it simply cannot ever be reconciled in the manner that the government of Canada is asking you to do. And it's for that reason, regardless of any of the other elements of the test, that we would submit that the court simply can't conclude that the regulation of greenhouse gas emissions in Canada is a matter of national concern. On that point, again, I would echo the submissions of my friends that there's a difference between something being a matter that is troubling or problematic for Canada to deal with as a society and the constitutional concept of a national concern. Those are two different things. It's not my intention here today to suggest that greenhouse gas emissions or the regulation of greenhouse gas emissions isn't a problem that Canada needs to address. So on that point of is this reconcilable? Is this a matter that we can consider to be reconcilable with the division of powers? We have to consider what federalism is in Canada, what that means. Now, there's been some submissions on that from my friends from the government of Saskatchewan this morning. I wanted to briefly go through the key points of that from the position or the perspective of the United Conservative and those Albertans that it represents. And what I intend to do is work you through how, in our submission, federalism also includes a consideration of the concept of subsidiarity, which is an emerging constitutional doctrine that I'll get to in a moment, but Professor Hogg identifies as something that, while it wasn't identified as a theory, explains the manner in which the powers were divided up at the time of Confederation. So what I'll do is hit on the high points of federalism from our perspective and then deal with that issue of subsidiarity, which is really what I wanted to hit on today. What the court, federalism was identified by the Supreme Court of Canada, and my friends touched on this morning, as a fundamental organizing principle of the Constitution. That was in the Quebec reference case, the Quebec secession case, I'm sorry. And what the courts have said since then is that what that means, or what federalism means, is that the federal and provincial governments are coordinate, not subordinate. The federal government is not a level of government above the provincial governments. And what that means is that you can't, one level of government or one government can't use its powers under the Constitution in a manner that effectively eviscerates the powers of another level. And what we would submit is that that's exactly what's happening here, is that by transferring regulation of greenhouse gas emissions to the federal government in a exclusive, and I see that I'm going well over my time here, so maybe what I'll do is just quickly address the idea of subsidiarity. That's the idea that lawmaking and implementation is best achieved at the level of government closest to the citizens that are affected by the legislation. I've worked through how that principle has emerged since the Quebec secession reference, but it's the idea that the provincial government is most responsive to the needs of citizens, to local distinctiveness, and to population diversity. Those are all concepts that were recently recognized by the Supreme Court of Canada in the Como decision, where the court stressed that the purpose of federalism was to allow provinces to develop their economies in a manner that's consistent with local concerns. So I would invite you to review the submissions that we've made on that point. I acknowledge that in the assisted reproduction case, the court was split 4-4 on the question of subsidiarity. Since that time, the Supreme Court in the Canadian Western Bank case again suggested that it was appropriate to narrow the application of the interjurisdictional immunity doctrine, because to do otherwise would undermine the principle of subsidiarity. So this is a concept that is emerging in Canadian constitutional law. It's a concept that explains how the division of powers were originally divided between the provinces, and we would submit that it's an important consideration for this court when determining how to reconcile the Government of Canada's claim for exclusive jurisdiction over greenhouse gas emissions and the existing provincial powers over property and civil rights, over local economies, and over local industries. And just on that point, I would stress that when you look at Part 2, the Government of Canada has, in determining the emission thresholds, they have calculated industry-specific thresholds, and they've determined that certain industries are emission intensive and subject to high competition from other jurisdictions, and they've allowed them a higher percentage of their average emissions than other industries. And this is incredibly problematic for the provinces, and we would submit that to allow the federal government to make decisions as to which industries within Alberta or other provinces should get the benefit of that increased calculation or that increased subsidy of their emissions is completely inconsistent with the idea of federalism, completely inconsistent with the idea of allowing the provinces to develop their own economies, and completely inconsistent with the existing authority of the provinces to regulate industry within their provincial boundaries. And subject to any questions that the court might have, those are my submissions.
Thank you very much, Mr. Martin. Next intervener is Agricultural Producers Association of Saskatchewan, Mr. Grubb and Mr. Awan.
My lords and ladies, we intend to principally address two areas. First, that the pith and substance of this act is to regulate provincial business and consumer activity. And secondly, that the test for legislating under the national concern branch of Canada's POG power has not been met in this case. Turning first to the pith and substance of the act, the court, of course, will have regard to both the purpose and the effect of the act. We say that the purpose is to regulate provincial business and consumer activity in order to reduce the use of fossil fuels. That is evident, we say, firstly, from the provisions of the act. This area has been covered by Saskatchewan, but I intend to highlight some specific provisions which we submit the court should pay attention to. Under Part 2 of the Act, Section 174 imposes the obligation to pay compensation on covered facilities which are emitting GHGs in excess of the applicable emissions limit. A covered facility is defined in the Act as including any facility located in the province which is designated by the minister. And those designations occur under the regulations which have been passed under the Act. The regulation defining a covered facility is titled the Notice Establishing Criteria Respecting Facilities and Persons and Publishing Measures. So it's a rather long title. Section 3 of this regulation defines the covered industrial activity as essentially including any processing activity that's related to or utilizing fossil fuels ranging from fertilizer and cement production to food and vehicle production and everything in between. The second regulation that I draw your attention to is titled the Greenhouse Gas Emissions Information Production Order, which specifies reporting requirements for particular facilities which are set out in parts 1 to 20 of that regulation. This was intended to come into force, I believe, January the 1st of 2019. Hasn't come into force yet, but is expected to do so at some point. And in summary, this regulation targets approximately 30 to 40 types of facilities in food production, natural resources, and manufacturing. So we invite the court to closely inspect those provisions and those regulations. Turning then to Part 1 of the Act, Section 55 of the Act requires producers and distributors of natural gas and all other fuels in Saskatchewan to register as distributors and thus be subject to the fuel charge. And in this regard, I note that paragraph 49 of Canada's Factum confirms that the fuel charge under Part 1 will apply to fuels produced, delivered, or used in a listed province and then be passed on to consumers. Now, with respect to the Act, my lords and ladies, we also highlight the preamble, which is referenced at paragraph 38 of Canada's Factum, and the Hansard speeches of the Federal Minister of Environment cited at paragraphs 40 to 41 of Canada's Factum. We see a consistent reference in those speeches and the Hansard to behavioral change in the provincial economy. We also say, my lords and ladies, that the pith and substance of the Act is evident from the legal and practical effects of this Act. In terms of the legal effect, there's no dispute that Canada's expectation is that fuel producers and retailers will pass on the emissions charges and the fuel charges to consumers in the form of higher energy prices. However, regulation of fuel pricing in the province clearly falls within provincial jurisdiction over intra-provincial trade and commerce. We direct you in particular to the Home Oil Distributors Limited versus British Columbia judgment of the Supreme Court of Canada from 1940, where the court was clear that it was within the province's legislative competence to regulate the price at which coal and petroleum products were sold in the province. Therefore, we say that the legal effect of this Act is to take over or assume concurrent jurisdiction over an area of trade and commerce that's been recognized as being within provincial jurisdiction as early as 1940. Turning then to the practical effect, much of the government's arguments and evidence are focused on how effective this Act will be in requiring business and industry to transform the way that they do business and requiring consumers to alter their economic and day-to-day activity. We direct you in particular to paragraphs 42 to 44 of Canada's Factum, which addresses why carbon pricing is one of the most effective ways of reducing emissions. Also paragraphs 113 to 115 of Canada's Factum, which essentially says that these charges are the regulatory scheme within themselves. We agree, my lords and ladies, that these charges are going to have a significant impact on industry and business in Saskatchewan. We present the court with the example of how carbon pricing will impact agriculture. The Act is going to apply to producers and distributors of key inputs for the agricultural sector. The Act will apply to trucking and railway companies, including those operating entirely in Saskatchewan. And these costs are going to be passed on to farmers in a context where they are price takers in a global market. This really has an extraordinary impact on farming because there's nobody that they can really pass on these costs to. The further point to make, that we make in terms of the practical effect is that Canada is really speaking in hypothetical terms when it tries to minimize the Act's impact on the provincial economy by characterizing it as behavior modification. And in this regard, my lords and ladies, there should be 2 points which we say are obvious and not in dispute. Firstly, for at least the last century, our societies and provincial economies have been heavily dependent on fossil fuels. Secondly, reducing our dependence on fossil fuels necessitates a transformation and restructuring of key aspects of our provincial economies. And that is really what this Act is aimed at doing, transforming key aspects of provincial economies in order to reduce greenhouse gases. The Act has to do that in order for Canada to say that it's going to be effective. And the example that we invite the court to consider is that when you raise prices which consumers have to pay for fuel on a day-to-day basis, the Act intends to encourage consumers to buy more electric and hybrid vehicles at local dealerships, to rely more heavily, for instance, on mass transit. And these changes, we say, significantly impact the provincial economy. They implicate the province's vital interests in areas such as the availability and funding of mass transit in provinces such as ours, which have a dispersed population. It's the provinces and not Canada, we say, that are properly positioned and authorized under the Constitution to undertake these changes. And this ties in, my lords and ladies, with the rationale for the distribution of powers under the Constitution Act of 1867. The first rationale we highlight is the principle of subsidiarity, the idea that decisions are best made at the level of government closest to the citizens affected. This principle is cited by the Supreme Court at paragraph 45 of the Canadian Western Bank versus Alberta case in narrowly reading the scope of interjurisdictional immunity. It was also cited by the Supreme Court at paragraph 73 of the first reference on the National Securities Regulation in 2011, when the court narrowed the scope of the federal power over general trade and commerce. And we say that it's particularly applicable when it comes to the issue of how to address climate change in the context of a federalist constitution. The province, we say, my lords and ladies, is in the best position to address the pressure points and the flexibility in the provincial economy and then implement a plan to address climate change. And in this case, that's exactly what Saskatchewan has done. And I want to talk about that plan, about the Saskatchewan plan in the context of the POG power and particularly the provincial inability test. My Lord, a summary of the province's plan is, of course, part of Saskatchewan's record. We've summarized key aspects of it at paragraph 15 of our factum to illustrate that the province has exercised its jurisdiction over climate change concerns arising from provincial trade and consumer activity. And in summary form, what that sets out are specific GHG reduction techniques in agriculture, targets and techniques in the area of power generation and oil and gas, carbon pricing for large industrial emitters in the private sector, requirements to contribute to technology and innovation, and GHG monitoring and reporting requirements. And this was preceded by a significant process of consultation that was undertaken in the province prior to the implementation of the strategy. So what we say is that the problem Canada is really seeking to solve through this act is not provincial inaction, it's rather to negate provincial unwillingness to address climate change in the specific way that Canada has prescribed. And to tie this in with the first part of the POG test, which is whether there's an issue of national concern, the specific prescription from Canada seems to be rooted in its ratification of a number of international treaties. And that's highlighted at paragraphs 16 and 33 of Canada's factum, including the reference to the preamble of the Act. And the point that is made repeatedly is that carbon pricing is essential to meet Canada's targets under the Paris Agreement. We say that's reading in through the POG door the fact that Canada has no jurisdiction to initiate legislation implementing treaty obligations it has signed up for. My lords and ladies, with respect to the second part of the POG test, the scale of impact on provincial jurisdiction, we say it's significant. It cannot be reconciled with the distribution of powers under the Constitution, and particularly the provincial power over trade and commerce for the reasons I've outlined. I intend to briefly talk about the federal power over trade and commerce, given that some of the intervenors are seeking to justify this legislation under that power. My lords and ladies, in order for that power to apply, there are 5 criteria which must apply, laid out in the General Motors case. And in this case, we say that the Act does not satisfy the final 3 criteria of that test. The rationale for those last 3 criteria are set out at paragraph 84 of the Supreme Court's judgment in the 2011 reference on the Securities Act. The court says there, the final 3 indicia direct our attention to whether the matter is one of genuine national importance and scope that goes to trade as a whole in a way that is distinct from provincial concerns, thus invoking Parliament's unique power. When we consider the final 3 criteria and apply it to the Act, we see that it does not go to trade as a whole in a way that's distinct from provincial concerns. With respect to the 4th criteria, at paragraph 83 of the securities reference, the court explains the 4th criteria as follows. The Act must be something that the provinces acting individually or in concert could not effectively achieve. To put it another way, the situation must be such that if the federal government was not able to legislate, there would be a constitutional gap. My lords and ladies, we say that in this case, the provinces are capable, acting alone or in concert, to pass legislation relating to carbon pricing. A number of provinces have passed that type of legislation. Saskatchewan has passed legislation such that Part 2 of the Act does not apply to private industry in the province. There's no constitutional gap here which Canada must fill. All the provinces have the ability to deal with climate change arising from the operation of provincial business and consumer activity. With respect to the 5th criteria, we say that the failure to include one or more of the provinces in the federal carbon pricing scheme does not jeopardize the successful operation of carbon pricing in other parts of the country. In this case, if provincial industry and consumer activity are not regulated, it would not jeopardize the ability of the federal government to regulate the areas under their jurisdiction, which are considerable, and include, for instance, interprovincial trade and commerce and greenhouse gases arising from that area. It will not jeopardize the ability of other provinces to implement their carbon pricing schemes. And notably, my lords and ladies, British Columbia and Canada are here touting how effective the BC carbon pricing scheme has been, even though Saskatchewan has not implemented carbon pricing similar to that under Part 1 of the Act. In the interest of time, I am not, actually I'll briefly address the third criteria as well. We say that the legislation is not targeted at trade in general. The pith and substance analysis suggests that really the legislation is directed at business and consumers in the province, particularly in relation to fossil fuels. And I've reviewed how that area has, at least going back to 1940, been recognized as an area of provincial jurisdiction. My lords and ladies, with respect to remedies, in terms of our concluding comments, we seek a declaration that the Act as a whole is ultra vires of Canada's legislative competence. We say that this declaration is not going to frustrate...
I don't know that in a reference case it's open to anyone to seek a declaration of invalidity, and it's certainly not open to an intervener to seek a declaration of invalidity.
Certainly we seek that court's opinion, my lords and ladies, and the point is well taken. We say that if this legislation is found to be ultra vires Canada's legislative competence, it will not frustrate the action against climate change. Saskatchewan has exercised its jurisdiction to develop a climate change strategy. It would be open to Canada to introduce other legislation aimed at GHGs in the considerable areas where they have jurisdiction. And the net result, we say, of that would be the cooperative approach to the issue of climate change, where federal and provincial plans are operating side by side. And my lords and ladies, subject to any questions from the bench, those would be our submissions.
Thank you, Mr. Awan. And finally for today, International Emissions Trading Association, Ms. DeMarco and Mr. McGillivray. DeMarco, I should say that we realize that in many ways you fit more happily on the other side of the room, but we did have to make some efforts to balance out the amount of work we have to do in each of the 2 days. And in your submissions, you do have a pretty significant qualification as to the validity of the Act, or at least how it needs to be read to avoid constitutional problems. So we've made the decision to put you on the speaker's podium today, and I appreciate you accommodating that. And you'll want to make sure in your submissions to take the opportunity to deal with this important exception, at least as I understand it, in terms of how the Act can play out constitutionally.
Thank you, my lord. I realize that I am the fulcrum today in more ways than one, and at the end of your day, so I will try and be as succinct as possible. In brief, during my intervention, I would like to cover 3 specific areas to support AIDA's general position that the impugned legislation is constitutionally valid pursuant to the trade and commerce or alternatively criminal law powers. However, to the extent that the Act, when it is fully implemented, encroaches upon a core element of exclusive provincial jurisdiction or a provincial carbon pricing regime of greater GHG reducing stringency, it should be interpreted consistent with the balance of powers and read down if required. First, I will clarify certain facts that should shape the court's consideration of the pith and substance, the purpose and effect of the Act. Second, I will address the constitutional validity of the Act pursuant to the trade and commerce power and touch upon the indicia set out in the General Motors case. I will not, unless the court otherwise requests, touch upon my alternate submissions regarding the criminal law power, and I note that my friends from the Canadian Environmental Law Association will cover that to some extent tomorrow. Third and finally, I will briefly address AIDA's submissions on applicability in the event that the yet-to-be fully implemented Act encroaches upon a core element of an area of exclusive provincial jurisdiction. Before I get into those three main submissions, I would like to just provide a quick introduction to AITA, as AITA appears to be one of the few voices in the room today directly representing Canadian and international business and industry. Many of AITA's members are emitters. All of AITA's members support well-designed carbon pricing and related market-based approaches to facilitate environmental integrity and low-cost approaches to addressing climate change. Very generally, AITA submits that there is no single issue that begs the promise of cooperative federalism in Canada more than climate change. AITA hopes that its submissions will assist this court in realizing that promise. So first, let me just address some of the facts specifically set out by my friends that do not support the submission that the act is as cut and dry as stop producing the product or pay, as my friends have indicated. Specifically, if I can refer the court to the record of the Attorney General of Canada, Volume 1, Tab 1, including the affidavit of Mr. Moffat at paragraph 100, and specifically Exhibit V or 5 to that affidavit entitled Carbon Pricing Compliance Options under the Federal OBPS.
Could you just repeat that?
Yes, it's Exhibit V or 5 to the affidavit of Mr. Moffat, and it's entitled Carbon Pricing, Compliance Options under the Federal OBPS. Mr. Moffat's affidavit speaks to the emissions trading aspects of the scheme outlined in the Act, or the compliance flexibility that is afforded through sections 174 and 175 of the Act. Those sections allow emitters that are under their emission standard to create surplus units and trade those units to emitters that are over their applicable standards. Emitters that are over their standards may also potentially purchase offset credits to address that overage. So it is not simply as cut and dry as pay or stop producing. More broadly, the Act also includes, through Section 186, a registry of accounts to affect compliance and trading. And Section 192 provides for regulation-making authority that allows trading of surplus emissions and related compliance obligations. At the chart at pages 4 and 5 of our factum at paragraph 13 has a quick summary table for your ease of reference. That's in the factum proper. Paragraph 14 of our factum outlines the 28 plus industry sectors and activities that are covered by the scheme. This is well beyond simply the energy sector. The key elements include a regulatory scheme that implements a regulatory charge on fossil fuel delivery, use, and imports, greenhouse gas emission standards, and flexible compliance trading, accounts for trading and tracking emissions, prohibitions and penalties, and a stringency provision. The Hansard and the preamble of the Act also support that the purpose of the Act is more specific than simply behavioral change, and that the central purpose of the Act is to decrease greenhouse gas emissions in a cost-effective manner through a bifurcated carbon pricing and compliance trading mechanism that is consistent with Canada's obligations under the Paris Agreement. Its intended effect is to decrease greenhouse gas emissions in a cost-effective manner, but we note that the Act has yet to be fully implemented for certain sectors, including electricity. Its dominant purpose is not to raise revenue. It is not to regulate the environment broadly. It is not to regulate all gases from all sectors. The pith and substance of the Act appears to be to regulate greenhouse gas emissions in a cost-effective manner through a carbon pricing and trading mechanism. Your judicial art appears to be to crystallize that down to the fewest words possible, so if I can try and do that for you, the pith and substance of the Act appears to be the creation of a carbon pricing and trading regime. We therefore submit that the pith and substance falls within the federal government's trade and commerce power under Section 91(2) of the Constitution. And that brings me to my second main submission, where I will outline the 5 indicia set out in the General Motors case and apply them to this case. Very briefly, the 5 indicia set out in the General Motors case, which is included at tab 3, page 25 of our Book of Authorities, which was also adopted or followed in the securities reference, which is included at tab 5 at page 139 of our materials, includes the following 5 criteria. First of all, the Act has to be part of a general regulatory scheme. Secondly, the scheme has to be monitored by continuing oversight of a regulatory agency. And this is found in our factum at paragraphs 27 through 35 for your reference. Third, the legislation has to be concerned with trade as a whole and not just a particular industry. Fourth, the legislation has to be of a nature such that provinces acting jointly or severally are constitutionally incapable of enacting it. And last but not least, the Act, or the failure to include one or more provinces in the scheme, jeopardizes its successful operation. So applying those 5 indicia to the case at bar, first in relation to the general regulatory scheme, as outlined on our submissions on pith and substance, the Act sets out a very broad regulatory regime with a charge on fossil fuel delivery, use and import, greenhouse gas emission standards, flexible compliance trading, accounting, registration, trading and tracking emissions, prohibitions and penalties, and a stringency mechanism. This is clearly, in our submission, a general regulatory scheme. Secondly, the regulatory scheme is monitored by the oversight of the Ministry of Environment and Climate Change with the assistance of the Ministry of National Revenue. Third, as discussed, the Act applies to some 28 sectors or activities across the Canadian economy. The Act is concerned with greenhouse gases and trade in compliance instruments as a whole, and not just in relation to a particular industry. Fourth, the legislation affecting interprovincial trade and trading in greenhouse gas compliance units is such that the provinces acting jointly or severally are incapable of enacting it. And I'd like to point out that this is distinct from general provincial jurisdiction to regulate greenhouse gases, which we submit the provinces certainly do have. It's the interprovincial nature of the greenhouse gas standards and trading that pose challenges for provinces to jointly or severally constitutionally validly enact.
You correct me if I'm wrong, of course, but Ontario and Quebec had or did have cap and trade systems, right?
Yes, and in relation to those systems, the issue of leakage and competitiveness from non-participating jurisdictions was very significant, and transferring among borders from non-participating provinces was very problematic as well. So these two elements frustrated or jeopardized the intent of the act that you now have before you. And finally, that is the last point. The failure to include one or more provinces in the scheme does create emissions leakage or competitive issues, and we are guided by the submissions of the Attorney General of British Columbia in this regard. So AIDA summarily submits that the Act therefore meets the indicia and validly falls within the federal trade and commerce power. In doing so, we note that those indicia are not exclusive and are not exhaustive, according to Chief Justice Dixon in the General Motors case. And we would urge this court, like that court, to take a purposive approach to the application of the criteria. Third and finally, AIDA submits that the issue of applicability of the Act is an important one. We note that the Act is not yet fully implemented for sectors including electricity. And to the extent that the Act significantly encroaches upon a core element of an area of exclusive provincial jurisdiction, such as electricity pricing or facilities for electricity generation, or the Act invalidates an otherwise valid provincial carbon pricing and trading scheme of greater greenhouse gas reducing stringency, it must be interpreted by the court in a manner that's consistent with the balance of powers. In this regard, it is no different than any other jurisdictional challenge. Should a conflict or encroachment arise when the Act is fully implemented, such conflict should be resolved in a manner that is consistent with the principles of cooperative federalism, subsidiarity, interjurisdictional immunity, and last but certainly not least, the express provisions of Section 91, Section 92, and Section 92A of the Constitution. Those are our...
What does the doctrine of paramountcy come into all of that?
To the extent that there is overlapping and coordinate jurisdiction on the same issue, then the doctrine of paramountcy would apply as it would in any other act to provide the act with paramount jurisdiction. I would note, however, that both Saskatchewan and the federal government have now existing carbon pricing regimes and output-based performance standards that do not appear to conflict. They appear to be coexisting well. Those are our submissions. Should the court have any other further questions?
All right. Thank you very much, Ms. DeMarco. So, Council, that brings us to the end of day one. We'll reconvene tomorrow morning at 9 o'clock to hear the submissions of the Attorney General of Canada.
Please rise.